Okay, that did it. So you're now live on YouTube. Okay. I can't switch, so I'm just going to shut off my camera and video, and I'll shift um, cam. If you, because do you still have all the abilities to do everything you need to do?
No, I'm not even a co-host at the moment.
Okay, all right. Okay, now do you have, sorry, now do you have the ability to do what you need to do?
I believe so. Let me. Yes, I should be all set.
Okay, and Aaron, you're all set as well? Okay. All right. I'm just going to leave this up running in the background. I'm going to turn my camera off and my audio off. I just don't want to disconnect and then lose the YouTube feed, and then we're back to square one again. Okay. So you're all set.
Thank you, Josh.
Thank you, Josh.
No problem.
Okay, are we ready, Kim? Okay. Good morning, everyone, and welcome. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Committee on Executive Departments and Administration. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the Right to Know law. As chair of the Senate Committee on Executive Departments and Administration, I find that due to the state of emergency declared by the governor as part of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and/or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. Number 4, in the event the public is unable to access the meeting, it will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. Number 6, finally, let's start the meeting by taking a roll call attendance. When each member states their presence, also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know. I will call the roll call. Senator Reagan.
Senator Reagan, I'm in my office by myself.
Senator Ricciardi.
Good morning, Senator Ricciardi. I'm in my home in Bedford alone, but my husband is in another room.
Thank you. Senator Kavanaugh.
Hello, Kevin Kavanaugh. I'm at my home in Manchester, and my wife and youngest son are in the house.
Senator Prentice.
Good morning, Chairwoman Carson. I am in my home in West Lebanon, New Hampshire, and my husband is in a different room, but in the house. Thank you.
Thank you. And Senator Carson, I am at my home in Londonderry, and I am alone. Okay, so let's get started. We have one bill that we're hearing today, which is Senate Bill 133. This is an omnibus bill. So I am going to be introducing the bill, and I'm going to be then reading through the different parts of the bill. Good morning. I have my name is Sharon Carson. Senator Prentice, did you have a question?
No, I just wanted to make a declaration when it's appropriate.
Okay, thank you.
Let me know. Thank you.
Good morning. My name is Sharon Carson, and I have the pleasure of representing Senate District 14, which comprises the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 133 FN, which is an act adopting omnibus legislation related to occupational licensure. This is an omnibus bill, and so I'm going to be reading through the parts of this bill. Part 1 is LSR 21-0964, relative to the definition of licensing agency for the purpose of licensing places of assembly, was sponsored by Senator Carson. Part 2, LSR 21-1009, establishing a limited plumbing specialist license, sponsored by Senator Gaida. Part 3, LSR 21-0506, repealing the Emergency Medical Services Personnel Licensure Interstate Compact, sponsored by Senator Rosenwald. Senator Prentice, would you like to make your declaration now?
I would like to make my declaration now. I have filed a declaration of intent with the Senate clerk. I have a conflict with 133, Section 3, and I will not be participating in the discussion.
Thank you, Senator Prentice. Section 4, LSR 21-0207, relative to hearings of the New Hampshire Board of Nursing, sponsored by Senator Ward. Part 5, LSR 21-0838, relative to membership of the Professional Standards Board, sponsored by Senator Khan. Part 6, LSR 21-0846, adopting the Audiology and Speech Language Pathology Compact and Occupational Therapy Licensure Compact, sponsored by Senator Sherman. Part 7, LSR 21-0859, relative to the licensure and regulation of music therapists, sponsored by Senator Avard. Part 8, LSR 21-0899, relative to the authority of the Office of Professional Licensure and Certification for administration, rulemaking, and enforcement of investigations, hearings, and appeals, sponsored by Senator Reagan. Part 9, LSR 21-0928, relative to skilled professional medical personnel, sponsored by Senator Ward. Part 10, LSR 21-0973, relative to temporary licensure of certain licensed nursing assistants, sponsored by Senator Hennessy. Part 11, LSR 21-1011, relative to the revocation of licensure for licensed emergency medical service units and emergency medical service vehicles, sponsored by Senator Prentice. Part 12, LSR 21-1050, relative to schools for barbering, cosmetology, and aesthetics, sponsored by Senator Reagan. Part 13, LSR 21-0277, relative to telemedicine provided by out-of-state psychologists, sponsored by Senator Reagan. In Part 14, LSR 21-1049, establishing program rules within the Department of Health and Human Services for sanitary production and distribution of food, sponsored by Senator Gaida. Okay, we are going to go ahead and start with Part 1. And as the sponsor of Part 1, again, I will just for the record note, I am Senator Carson, and I represent Senate District 14. This Part 1, relative to the definition of licensing agency for the purpose of licensing places of assembly, is a refile from last year, and it was passed by the Senate ED&A committee, but unfortunately did not make it through. So it was refiled, and we have this morning the fire marshal who requested this legislation be filed, who will be able to speak to it. Are there any questions from the committee? Okay, seeing none, we're going to go on to Part 2, and we will recognize Senator Gaida.
Senator Gaida, you should be able to unmute yourself. Senator Gaida.
Yes, good morning.
Good morning, Senator Gaida.
Let me turn up my volume here. Okay, for the record, Senator Bob Gaida, District 2, 27 towns and 3 counties, and prime sponsor of Section 2, Part 2 of this legislation, Senate Bill 133. This bill grew out of conversations with several small licensed plumbing outfits in the district. We current law prevents an apprentice from doing anything without direct supervision for 8,000 hours of training. Now, I, as a citizen, can change the washer in my sink. I can change the seal around my toilet. I can do anything that are not considered complicated, but the apprentice is working under supervision of a plumber can't do that. It's a terrible inhibition to their professional career progression. Many start that don't finish because they're waiting for 4 years to be able to do anything. So I put this bill together working with Fire Marshal Paul Parisi, with the plumbing board, the mechanical board, and with Executive Director of OPLC, Lindsay Courtney. And collaboratively, we developed the language in this bill that establishes a limited license, limited plumbing specialist that would enable them to a person working with a company, a plumbing company licensed in New Hampshire, to do certain things. Now, we haven't defined those certain things because I, as a legislator, and Executive Director Courtney are not plumbers and don't know the field. But this bill allows them to develop the qualifications that a person would need to be considered and licensed as a licensed plumbing specialist, a limited plumbing specialist, to practice in the state. That will happen in dialogue between OPLC and the mechanical board. One minor change in the bill that I would ask, and I think it's an editorial, and it has been agreed to by both the mechanical board, Executive Director Courtney, and Fire Marshal Parisi, is if you go to line 21 of the bill. I'm sorry, not line 21. Go to line 4. I'm sorry, on page 3, line 4.
Okay.
And you'll see it says, in consultation with the state fire marshal. Okay. That can be struck. That can be struck out. I talked to Fire Marshal Parisi last night. I believe he'll testify to that here today. It takes him out of the loop, makes the development of rules applicable to this limited plumbing specialist much more simple. The plumbing board is in agreement with it. I'm sorry, the mechanical board. And so I would ask that minor change. And with that, I'm happy to answer any questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Okay, seeing none. Thank you very much, Senator.
Thank you, Madam Chair, members of the committee.
Okay, next we're going to move on to part 3 and recognize this prime sponsor, Senator Rosenwald. Senator Rosenwald is not available this morning, and she has Ms. Gallagher here to testify on her behalf.
Thank you, Madam Chair. I'm Jennifer Gallagher, Assistant to Senator Cindy Rosenwald from District 13. She has a conflicting prime bill introduction right now, so she requested that I introduce Part 3 of the bill for her. Part 3 repeals the Emergency Medical Services Personnel Licensure Interstate Compact, known as REPLICA. This was enacted several years ago, but has never been used. In fact, the nearest state that has adopted the compact is at least 500 miles away. The compact would not enhance public safety because New Hampshire already conforms to licensing and certification regulations from distant states. Senate Bill 540 from last year repealed REPLICA. It passed the Senate on a voice vote. It was then included in an omnibus bill that unfortunately was vetoed for other reasons. I hope you will recommend it as ought to pass again this year. Thank you, Madam Chair and committee members.
Thank you very much, Ms. Gallagher. Does anybody have any questions for Ms. Gallagher? Okay, seeing none, thank you very much. Next, we're going to move on to part 4, which is LSR 210207, and recognize the prime sponsor, Senator Ward.
Good morning, Madam Chair and members of the committee. I'm here to introduce a bill for the New Hampshire Board of Nursing. They are requesting that the board may hold adjudicative hearings concerning allegations of misconduct or other matters within the scope of this chapter. And that is chapter 326-B:38. Such hearings shall be public proceedings. Any member of the board or any other qualified person appointed by the board shall have authority to proceed at such a hearing and to issue oaths or affirmations to witnesses. This was introduced last session, but didn't make it through the many omnibus bills, so it's being reintroduced this year. And I know that there will be people from the New Hampshire Board of Nursing testifying later.
Thank you very much, Senator Ward, and good morning. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Okay, next we're going to move on to part 5, which is LSR 210838, and recognize the prime sponsor, Senator Khan.
Good morning, Madam Chair.
Good morning, Senator.
I'm introducing Section 5 on behalf of the Department of Education. They've requested a change in the specifications of roles that would fill the Professional Standards Board for their licensed and certified employees that are working in the education field. There are 2 representatives from the department that are prepared to speak to this. Diana Fenton, their in-house attorney, and Steve Appleby, who leads the licensing and certification division. So I will leave to them the specifics to answer, but I'm glad to answer any specific questions, though, that the commission has of me. I should have introduced myself at the beginning. I'm State Senator Jay Kahn, District 10 in Keene. All right, there you go.
Thank you very much for your testimony this morning, Senator. Are there any questions from the committee? Okay, seeing none, thank you very much.
All right, have a good day.
You too. Next, we're going to move on to LSR 21-0846 and recognize the prime sponsor, Senator Sherman.
Thank you, Madam Chair. Can you hear me okay?
We can hear you fine.
Awesome. Thank you. For the record, my name is Senator Tom Sherman. I represent District 24, which is 11 towns on the seacoast. And I am introducing this bill or this component of the omnibus, Part 6, which adopts the provisions of the Interstate Audiology and Speech Language Pathology Compact and Occupational Therapy Licensure Compact. This language was produced in combination with the Council of State Governments and the American Speech Language Hearing Association, as well as OPLC. And I think they are here to provide the technical backup. I believe, Madam Chair, that you and I were both here in the legislature when I introduced a bill to create the nursing compact. And some compacts have worked out really well. I think there are others, including in this bill, where there might be a need to amend or change them. But in general, compacts, especially when supported by all the associations and by OPLC, increase the availability of workforce in the state, increase the portability of licensure, do not change the oversight or accountability of licensees, but they also are cost saving. So it's kind of a win-win-win-win, as long as everybody's in support. And on this bill, we have made sure that they're, as best as we can tell, that the associations and the New Hampshire chapters do support moving forward with this, as does OPLC, who actually brought it forward. I would bring attention to an amendment that is a very, very minor change. It's amendment 2021-0232S, and hopefully you have it. It is found in the bill. It is page 5, line 25, and it's amending part 6 of section 2 of the bill by replacing 2A RSA 326-F:15. And really the only change in this is in line 5 of the amendment from the current wording. And it's highly technical, just changing a few words to make it compliant. So I'm happy to take any questions if you have any.
Okay, thank you very much for your testimony this morning, Senator. Are there any questions from the committee? Okay, seeing none. I just want to make sure, Senator, that there are going to be folks that are going to speak to this today. This is pretty extensive, and I'm sure that the committee will have some questions to ask these individuals.
It is my understanding that they are prepared to testify and answer technical questions regarding the compact licensure.
Okay, thank you very much, Senator.
Thank you.
Okay, next we're going to move on to part 7. Excuse me, no, part 8, LSR 210859, and recognize the prime sponsor, Senator Abard.
Thank you, Madam Chair. Can you hear me?
We can hear you fine.
Oh, wonderful. Good. I'm going to make sure that my other Zoom is off so they can't hear me. I'm in HHS right now, so I appreciate you taking the time. I'm basically just going to read the bill. I know there are other people that want to testify on it, just the analysis. This bill establishes music therapy governing board in the Office of Allied Health Professionals for licensure and regulation of practitioners of music therapy. I do have written testimony that I'm sending to you, but on the second paragraph, if I could just read that.
Sure.
While many of you understand that there is a value in the power of music, many don't know that there are individuals in New Hampshire who are specifically educated and clinically trained to provide evidence-based, goal-oriented music interventions to individuals. This profession, recognized by the National Institute of Health, is called music therapy, and qualified professionals are board-certified music therapists. As a senator, many of you know that some people call me as the singing senator, and I can testify that I've seen, even in the Senate, where we have the Senate, where I sing to the kids, or in the House, I've seen children that basically look as though they're tuned out. They're not paying attention, and some with developmental disabilities. And I see that when I'm singing to them, they start engaging, and it reaches them. And it is evident that music has a role in mental health and in all around health. So it may be time that we start to recognize that and allow this to be a part of someone's overall health. So I'm just hoping that you take that into consideration as you consider this bill. Music is a very big part of our life. So, and with that testimony, I have to get back to HHS unless there is any specific questions that you may have.
Okay, thank you very much for your testimony this morning, Senator. Are there any questions from the committee? Okay, seeing none. Thank you, Senator.
Thank you, Senator.
Okay, next we're going to move on to part 8, and this is LSR 210899, and it is prime sponsored by Senator Reagan.
Good morning, Madam Chair. I bring before you today Part 8, and for the new members, this might look like we're trying to seize away the authority of the different boards, when the fact of the matter is the boards have been so reluctant to meet and make decisions and formulate rules and do investigations that we've transferred over a long period of time more and more pieces of the administration of the different professions that we license. So this is been at sometimes the behest of the boards and sometimes by the frustration of the legislature not being able to deal with the different professional boards. So this bill, and there are people here from OPLC to testify and support and explain, and I'll leave it at that.
Okay, thank you very much, Senator, for your testimony this morning. Are there any questions from the committee? Okay, seeing none. Thank you. Okay, next we have part 9, and this is LSR 210928, and this was sponsored by Senator Ward.
Again, thank you, Madam Chair, members
Good
of the
morning.
committee. I'm Senator Ruth Ward from the 8th District. I'm not going to tell the towns, there are 24 of them. This is something from the Medicaid, Medicare requests. In the long-term care that has to do with eligibility and service coverage authorization, RSA 151-E:3, section 2. And it has been a question that before it was skilled medical professionals. And the question was, who are these skilled medical professionals? So what kinds of education do they have to have? They need to use a special tool to decide on the eligibility of the clients. So the change that has come because of it is that only skilled professional medical personnel who are registered nurses and currently licensed in accordance with RSA 326-B may render an adverse clinical eligibility determination. I am not an expert on Medicaid reimbursement or money, so I will leave the rest of it to those people who can explain in further detail what this is all about. And that's it, and thank you.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none. Thank you. Next, we're going to move on to part 10. This is LSR 21-0973, sponsored by Senator Hennessy.
Good morning, Chairwoman Carson and members of the committee. I am Senator Erin Hennessy, and I represent District 1, which is Northern Grafton County and all of Coos County. And I am here before you today to introduce Section 6 of this omnibus bill, which is on page 48, and it's relative to temporary licensure of certain licensed nursing assistants. Prior to the pandemic, New Hampshire saw a very sharp need for licensed nursing assistants, or LNAs. We have a workforce shortage, especially in our healthcare arena. And the pandemic only heightened this need for LNAs. Executive Order 42 allowed for what is called a temporary health partner. And that person would be able to go in once they've had I believe it is 10 hours of training, to act and assist our health facilities, especially our long-term care facilities, in meeting the needs of the healthcare providers that they had. And what this bill does is allows those temporary healthcare partners who have been working and being supervised on the job to transition into an LNA without going through the traditional LNA process. And I'm happy to take questions, but I know there are a lot other people on the line that have greater knowledge on this temporary healthcare partner than I do.
Thank you very much for your testimony this morning, Senator. Are there questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, next we are going to go to part 11. And this is LSR 1011, and this was filed by Senator Prentice.
Good morning, Madam Chair and members of the committee. On behalf of, as a request of the Department of Safety, I filed this LSR and ultimately packaged into this Bill 133. What we're seeking to do here in Section 11 are two things. One is to make we're seeking to amend the language so that the Commissioner of the Department of Safety has the ability not just to revoke or suspend a license, but to add in as an optional letter of concern. As it stands today, should a concern come forward that is more of an organizational issue, not a provider issue, the commissioner's hands are tied to either, if it comes up through the Department of Safety and is investigated, either to revoke or suspend. In healthcare, under what we call just culture, we have created an environment so that when mistakes are made or there are issues that are organizational, they are handled in that process of just culture. So people are healthcare providers are more likely to come forward to discuss not only the organizational issues that impact the work that they do, but the mistakes that they may have had along the way. They differ from issues of falsification of certification or areas of misconduct. So we wanted to give this tool. You have a letter from Dr. Rob Ricks, who's the chair of the Medical Control Board, that speaks to this. It should be in your file. And then secondly, we seek to change the language from the commissioner shall to the commissioner may in terms of issue a letter of concern, revoke, or suspend. Again, wanting to untie the commissioner's hands. And secondly, in research that was done, not only by myself, but members of the Department of Safety, who I believe are here to speak today, and Dr. Rob Ricks from the EMS Medical Control Board, we found that the physicians and the nurses have language that allows may versus shall in some of these circumstances. And I think this better aligns us with the other healthcare professions. So at that point, I'd be happy, or at this point, to answer any questions you have.
Thank you very much for your testimony this morning, Senator. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to move on to part 12. This is LSR 21-1050, and this is relative to schools for barbering, cosmetology, and aesthetics, sponsored by Senator Reagan.
Good morning, Madam Chair. There are people here to explain what this is all about.
Okay, thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to part 13. This is LSR 21-0277, relative to telemedicine provided by out-of-state psychologists. And this, again, is sponsored by Senator Reagan.
So good morning again. In part 13, there is a disagreement between the constituent that requested this bill and OPLC. And so we'll hear from Dr. Warner and from Tom Broderick from OPLC to explain why they think we do need this or don't need this.
Okay, thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you again. And finally, we're at the last one, part 14. This is LSR 21-1049. Establishing program rules within the Department of Health and Human Services for sanitary production and distribution of food, which is sponsored by Senator Gaida.
Thank you, Madam Chair. Just a moment while I find the appropriate document here. Okay. Thank you, Madam Chair and members of the committee. For the record, Senator Bob Gaida representing the 27 towns in District 2. Senate Bill 133 includes this section on the food industry and the dissatisfaction of those they seek to regulate and sometimes overregulate. I was asked to intervene on behalf of those constituents because of a new regulation that many did not know was coming, or was included in new rules changes that were not advertised to many of the people who were put under those rules with significant impact on their businesses at a time when they could least afford it. I understand it's the public's responsibility to be informed, but I also believe it's the government's role to inform the public when they're about to create a situation in which the ruled do not see a need for regulation that's put forth. The Department of Health and Human Service response to questions that I posed, along with numbers of the advocacy for this bill, was met with the insistence that all stakeholders were part of the decision and all had been informed, and that is categorically not true. It wasn't correct. In fact, in one call, when asked to identify stakeholders, the answer was city or town health inspectors, in addition to the Lodging and Restaurant Association. That's a good group, but certainly not everyone, especially our smaller food establishments around the state, are members. So many of those small businesses didn't see this new rule coming. The new rule is simply this. It's a requirement for any food establishment to train employees so that they have on staff during their hours of operation a certified food safety specialist at an original cost of $300 per employee. The employer would pay that cost, but the employee would be the certificate holder. The biggest issue here is that if the employee is left to work that establishment to work for a competitor, the certificate would not leave with the employee, but simply become worthless, and the employee would then have to be recertified under the new employer, and the old employer would lose the employee. And as you know, there is significant turnover in the food service industry. So the costs related to this rule are very, very significant, and at a time when we can least afford them. In addition, there is no demonstrated need for this rule. The department produced statistics that essentially are not in any way, shape, or form probative of the fact that we need such a rule. And I'm sure that they can provide that for the committee. I'd be happy to do that as well. Since we started watching this DHHS process, the cost to be educated and tested has gone to $165. It's less, but still an additional $55 if you don't pass due to the ability of the instructor to teach. If you fail 3 times, you can't take it for a year. This is causing consternation, again, among businesses, especially the small businesses with high turnover employees who many times are in school and looking to complete their education. Originally, DHHS didn't want to work towards a reasonable solution that's reasonable to the small businesses, so I got involved. Rules have to have full force and effective law, and a rule can be made even if Jelkar says no, as you well know. The only real way for a senator or any other legislator is to make a law and to fix a rule. So the rules must comply with existing law. This rule section had a lot of issues, including another building code problem. In the early 2000s, we determined as a legislature that no department could create its own building code fiefdom. HHS in the food section has done that. We're amending the desire to determine plumbing and septic or waste codes as well for food establishments. This is a surprise to many who work with the Department of Environmental Services, who have their plans approved as the law states, and local building officials for plumbing and fire departments. We then have to go through the HHS folks as well. There's current negotiations moving forward, and you may have a copy from Legislative Solutions of a redraft of this, which I will submit as an amendment when we exec the committee. It's still under development, and we had conversations as late as yesterday to continue this process. It simply returns the reference to the 2017 code and removes the 2015 code. The rest of the changes are the same. This was done to alleviate concerns about temperature and other issues which the industry has no problem with. This is a complicated bill, and I appreciate your patience. I thank you for the time you've allowed us on this. There's an expert to help understand this issue from the business side who will testify, and of course, DHHS will as well offer their opinion. I'm almost certain the former Senator Clegg will be weighing in to help with this on behalf of his clients. I suggest I answer no questions at this time, allow those involved in the process to move forward. I can be reached by anyone at any time. These folks are waiting to testify now, and I rest my case. Thank you.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none. Thank you very much. Okay, now that we've gotten through all the different parts of the bill, we're going to start taking testimony from the public. Before we get started, and I hope the folks that are in the waiting room as well can hear, that I'm going to ask you to identify yourselves for the record, who you represent, and which part of the bill that you are speaking to. Okay? So why don't we start with Susan Adams.
Susan, you should be able to unmute yourself.
Hi, members of the committee. My name is Susan Adams. I am representing the American Speech Language Hearing Association, and I'm here to speak on the section of the bill that references the Audiology and Speech Language Pathology Interstate Compact. ASHA is in support of this bill, this section of the bill. We've been working with the Council of State Governments since 2017 to develop the language for this bill and have vetted it with numerous stakeholders from state associations, state legislators, other stakeholders, and state licensing boards. We've had numerous conversations with the OPLC about this bill, and we thank Senator Sherman for introducing this bill for us. I'm happy to answer any questions that you have about how this would work. It's very similar in form and function to other interstate licensure compacts that are currently in effect. We are the 7th one that has come out in the states, and we have many more following us. So, the compact really is just another method for licensure. It's just another pathway to allow people to practice within the state, allowing telepractice into the state or telepractice out of the state and in-person practice. So it would allow New Hampshire audiologists and speech language pathologists to practice in other states where they obtain a privilege to practice, and it would allow other audiologists and speech language pathologists from other states to practice into New Hampshire with a privilege to practice.
Okay, thank you very much for your testimony. Are there questions from the committee? Okay, Ms. Adams, I just want to make sure that I heard you correctly, that this compact is going to allow New Hampshire speech therapists and audiologists to work in other states, but is it also going to allow those folks from other states to work here in New Hampshire?
Yes, it would allow reciprocal, basically, licensure. So you'd have a privilege to practice in each state where you choose to work through the compact.
Okay, all right, I just want to make sure. Okay, thank you. Are there any additional questions? Okay, seeing none. Thank you very much for your testimony, Ms. Adams.
Thank you.
The chair is going to call Nahal Kalfas.
Nahal, you should be able to unmute yourself.
Yes, thank you. Can you hear me?
Yes, we can.
Thank you very much, Madam Chair, members of the committee. My name is Nahali Kalfas. I am legal counsel with the Council of State Governments. I'm here in that capacity. I am also a primary drafter of the Audiology and Speech Language Pathology Compact, as well as the Occupational Therapy Compact. Though I'm here in my capacity as legal counsel and drafter with Council of State Governments, I have also served as a board prosecutor for the past 16 years in my home state of North Carolina. And this has given me a unique perspective as to how a compact can strike the appropriate balance between safe and reliable public protection and the elimination of unduly burdensome regulation and disparate requirements. I think probably no other time in history has pointed to how badly we need to ensure access to care for citizenry in our states. And as my colleague Susan said, this bill is an alternative pathway to licensure, just like your nursing, your physical Therapy SIPACT compact. It is a mutual recognition model that functions much like your driver's license, wherein you achieve an unencumbered, clean home state license in a member state, and that allows you to obtain the privilege in every other state that is a member of the compact. This mutual recognition model has the added benefit of having been identified by the Federal Trade Commission as an active and effective tool to ameliorate antitrust concerns in their 2018 white paper. I respect the time of this subcommittee, so I know you have a long agenda. I would like to remain available for any questions, technical or otherwise, since I am one of the primary drafters of this and the occupational therapy bill. But I would urge your favorable vote on this important way to provide access and continuity to care to all of your citizenry.
Thank you very much for your testimony this morning. Are there any questions from the committee? Okay. I have a question for you. You were talking about the compact. We know how compacts work, but can you tell us who some of the partners are within this particular compact?
Well, in terms of partnership in vetting and stakeholding and moving forward, ASHA took a primary role in that because there's funding that is required to at least have the conversation. The actual stakeholder group was comprised of over 20, I believe over 24 people, and Susan Adams could help me with this, but it involved folks from all areas of the country, both in education, legislators, audiologists, speech and language pathologists, and association members. So it is a large group, and we do have, I believe we have a list, and we may have submitted a list of those who are in favor and have been working with the OPLC with regard to this bill.
Okay, thank you for answering that. Do you know if any other states have filed this legislation to enter into the compact?
Yes, thank you very much for the question, Senator. The compact has passed in 6 states currently. It is filed, I believe, in 13 additional states currently, and looks to be on target to pass this year, this legislative session. We need 10 states to make it an active live compact. And since we are at 6 and pending in so many other states and looking good, have moved through at least one side of several general assemblies, we do look to be on target. The states that are currently enacted are Wyoming, Utah, West Virginia, North Carolina, Louisiana. I think I'm forgetting one, sorry. And again, we are pending in about 13 other states.
Okay, thank you very much. Do the committee members have any additional questions? Okay, seeing none. Thank you very much for your testimony.
Thank you, Senator.
Okay, next, we're going to go to Christopher Arnold.
Christopher, you should be able to unmute yourself.
Thank you, Madam Chairwoman. My name is Christopher Arnold. I'm with the United States Department of Defense, and I will be speaking on parts 3 and part 6. Madam Chair, honorable members of the committee, the Department of Defense is grateful for the opportunity to support many of the policies reflected in Senate Bill 133. However, DoD wishes to express its opposition and concern to part 3 of the bill to repeal the Emergency Medical Services Personnel Licensure Interstate Compact, or replica. My name is Christopher Arnold. I am the Northeast Region Liaison for the Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. Our mission is to be a resource to state policymakers as they work to address quality of life issues for military families. According to the International Association of Firefighters, other states, such as Indiana, have enacted language to address certain concerns with replica. A potential first solution for Senate Bill 133 could be to amend Section 3 to propose modifications rather than an outright repeal of replica. Since these objections were first raised, work has been done at the national level to allay some of the concerns through rulemaking. Licensure issues for both our transitioning military members and the spouses have been a priority of DoD for several years. The issue is so important that the SecDef has made taking care of service members and their families a 4th line of effort in the National Defense Strategy. Subparts A and B of Part 6 of Senate Bill 133 recognize the benefits of interstate compacts by adopting the Audiology and Speech Language Pathology Compact and the Occupational Therapy Licensure Compact. Indeed, New Hampshire is one of only 8 states in the nation to have joined the other 4 major compacts: Replica, the Interjurisdictional Compact for Psychology, or SIPAC, the Nurse Licensure Compact, NLC, and the Physical Therapy Licensure Compact, PTLC. Occupational licensure compacts provide consistent rules that allow licensed members to work in other states through privilege to practice policies or to more easily transfer their license to a new state. The military provisions added to these compacts assist military members and their spouses to participate in these occupational compacts. A number of occupations are working with the Council of State Governments to explore additional compacts to support interstate commerce and interoperability. The fiscal year 2020 National Defense Authorization Act provided authority to DoD to establish cooperative agreements with CSG in order to make grants to develop additional occupational compacts. As our service members and their families move from state to state, obtaining licenses in order to maintain a career is very important. These compacts serve to relieve one of the many stressors of a military move. To date, 21 states have passed legislation to join Replica, and 3 states have legislation pending. It would be a step in the wrong direction if New Hampshire repealed Replica as opposed in Senate Bill 133. We are grateful for the tremendous effort that New Hampshire has historically made to support our service members and their families. DoD would request that this item be amended to continue New Hampshire's reputation as a military-friendly state while adopting the policies we support in the bill, such as the Audiology and Speech Language Pathology Interstate Compact and the Occupational Therapy Compact, for which we thank Senator Carson and Senator Sherman for their sponsorship and leadership, and including them in the provisions of Senate Bill 133. I have additional, comments on the specifics of the OT Compact and the ASL-PIC, but I think there's enough experts on today that I don't need to, go on too much. But I will say that the recent combinations of increased mobility of patients and practitioners, changes to the healthcare system, and the rise of telehealth, especially in response to the COVID-19 pandemic, has highlighted the need for clinicians to have the ability to practice across state boundaries with minimal barriers. Occupational licensure compacts like Replica, like ASL, PIC, like the OT Compact address this need for states. Further, occupational licensure compacts allow states to assist one another during emergencies and disasters with no need for governor's emergency decrees or state licensing board actions. DoD asks the committee today to support spouses of relocating active duty military personnel by enacting the OT Compact and ASL-PIC as proposed in Senate Bill 133, while reversing course and removing or amending Part 3 insofar as the EMS Compact to maintain New Hampshire's leadership in enhancing the exchange of licensure, investigative, and disciplinary information among member states. Thank you very much.
Thank you very much for your testimony this morning, Mr. Arnold. Are there any questions from the committee? Okay, seeing none, thank you again.
Thank you.
Next, we're going to go to Justin Romanello.
Justin, you should be able to unmute yourself.
Good morning. Thank you, Madam Chairperson and Senators. My name is Justin Romanello. I'm Chief of the Bureau of EMS for the state of New Hampshire. Thanks for allowing me a few moments to speak. I first want to express our appreciation for your continued service to the state of New Hampshire and our residents. I'm speaking specifically to sections 3 and 11. Excuse me. Although we have stated that we oppose this bill, we do so conflicted. Senate Bill 133 has many components that will greatly benefit grant staters. Sections 4, 5, 8, 9, and 10 all increase oversight to ensure that care is being delivered at a set standard. And sections 6, 7, 12, and 13 all increase access to care and services to our residents. As stated by Senator Prentice, Section 11 specific to the revocation of licensure for licensed emergency medical services units and emergency medical services vehicles will assist the Commissioner of the Department of Safety in the regulatory duties of the EMS system by providing options other than the suspension of revocation when an investigation warrants an actionable offense. This tool will benefit the EMS system greatly by providing a just culture that Senator Prentice mentioned, as well as what you will find in Dr. Ricks's written testimony. It does come with great surprise that in the same bill that promotes a healthcare compact, Section 6, that there also is Section 3, which includes repealing the Emergency Medical Services Personal Licensure Interstate Compact. To date, this compact has not been used within the borders of New Hampshire and has not been proven to be harmful to our residents. Although our residents have not directly benefited from the compact, most recently, Meredith Lund, Fire Chief of New Ipswich and wildland firefighter, deployed to the state of Colorado, a fellow compact state, in response to the devastating wildfires this summer. Because New Hampshire is a compact state, she was able to provide care to Colorado residents and her firefighting team without delay. This is just a single benefit of the compact and one that New Hampshire could rely on in the future. At the time of adoption in July of 2018, New Hampshire became the 15th state to join the compact, and most recently, Louisiana became the 21st state to join. The compact has been declared operational since March 16th of 2020, and since has been used countless times in many states to support personnel needs during the pandemic. Although the state of New Hampshire has not had to request assistance from fellow compact states during the pandemic, this is not to say that in the future it would not be needed, especially when closer states become members. In closing, the compact does not harm grant staters, and to the contrary, enables our EMS providers to answer the call or cry for help in other states when requested. By repealing the compact, we take this ability away from our 5,500 providers, as well as increases the hardships that those answering our requests in the future may face if we need that assistance one day. Thank you.
Thank you very much for your testimony this morning, Mr. Romanello. Are there any questions from the committee? Okay, seeing none. Thank you very much. Next, we're going to go to Mr. Bill Twombly.
Let's see. On my screen, something is popping up. Bill, you should be able to unmute yourself.
Thank you, Madam Chairman. My name is, yep, I'm on.
Yep, you are.
Thank you, Madam Chairman. My name is Bill Trombley Jr. I am the owner of Bill Trombley Plumbing Heating in Manchester, New Hampshire. I am also the chairman of the New Hampshire Mechanical Board. And I'm here simply to say that on part 2 of SB 133, the Mechanical Board is in favor of the language that was presented and also the strikeout that was presented earlier this morning.
Okay, thank you very much for your testimony, Mr. Trombley. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, next we're going to go to Michael Porter.
Michael, you should be able to unmute yourself.
Great. Thank you very much. Good morning, Madam Chairwoman and members of the committee. My name is Attorney Michael Porter, and I'm the administrator for OPLC enforcement. I'm here today to testify in support of Senate Bill 133, Section 8. I'd like to thank Senator Reagan for sponsoring this bill. OPLC has 2 primary missions. The first is to assist in strengthening the workforce in New Hampshire through ease of access to the professional licensure process. The second part of the mission, through enforcement of statutes and rules governing professional licensure, our mission is protection of the public health, safety, and welfare, while balancing due process rights of the licensees. Authorizing OPLC to administer complaints, investigations, disciplinary proceedings, and other administrative duties provides members of the public a centralized, consistent, and efficient point of access to each regulatory board when members of the public have complaints or concerns. The proposed enforcement process provides that consistency and efficiency from the initial complaint all the way to final adjudication. While no 2 complaints are alike, the manner in which each case is processed is and should be similar. Under the current system, each board has a unique mechanism to process complaints. By enacting a centralized complaint investigation and adjudication process, efficiency and consistency are achieved for all boards through close case tracking and monitoring. Currently, we have seen cases run 2 or even 3 years from the date of initial complaint to final adjudication. This is not efficient. It is not efficient for the members of the public filing the complaint or the licensee accused of misconduct to wait 2 to 3 years for a final outcome. By centralizing this process, we are better able to track the number of cases in total, broken down by board, where the case stands in the process. We can provide these statistics monthly to each and every board. One example I'm going to talk about is when a hearing notice is issued. When the board determines that final adjudication is necessary, a notice of hearing is issued. The parties then engage in settlement negotiations. Unfortunately, some of these negotiations can take months or even years. We are currently working on a process internally where if a board requests a matter to be heard, we have 60 days from the date of the decision of the board to negotiate a settlement. If no settlement is reached, then the notice of hearing is issued on day 60 and scheduled to be heard within 30 days. This will provide a time frame by which we have to either reach an agreement, move forward to prosecute, or dismiss if we have insufficient evidence. The complaint process is unique to all the various boards. We have been able to streamline since September the complaint process internally through standing orders. Complaints come in many variations. Some arrive in official complaint forms, others are in a narrative, in emails, and in some instances for medical professions, complaints come in via lawsuit. A number of boards, including the Board of Nursing, Cosmetology, Accountancy, and a number of others, have signed on to the standing orders that we have requested to centralize the complaint process through the Enforcement Division. As a result of the centralization thus far, we have been able to identify and address emergency matters rapidly. I'll give you a couple of examples. We were able to conclude an expedited investigation into the American School of Nursing, whereby in a matter of 4 days, upon learning of the alleged wrongdoing on behalf of the school, we were able to successfully suspend the nursing program amid growing fear the school would continue to seek funding from students while not having the financial viability to follow through with the education promised to those students. Since last Friday, we have received a number of complaints, 4 of which we identified as emergencies. Recently, not only have we suspended on an emergency basis some of these licenses, but we also enter into preliminary agreements not to practice. In one instance, most recently, it involved a pharmacist diverting a dose of Moderna COVID-19 vaccine. Other professionals diverting narcotics, alleged sexual assault, and alleged abuse of a child. These are just a sample, a very, very small sample of the cases that come through our office. Because we centralized our system through standing orders, we were readily able to identify those, protect the public immediately. At the same time, we've also been able to identify numerous complaints for various boards that do not comply with statutes or administrative rules, whether it be the complaint itself or through rigorous investigation. Respondent licensees have been cleared of wrongdoing. One example of that is with the Board of Nursing. In 2 short months, we were able to review and investigate 50 cases which were dismissed at the Board of Nursing. Some of these cases in the past had dragged on upwards of 1 to 2 years. We were able to gather the complaint, conduct the investigation, and have a final outcome by the Board of Nursing within about 60 to 90 days. A couple instances, about 120 days. Some cases that have reached a dismissal have been processed from complaint to board decision within a minimum of 60 days. That's an important figure right there because, again, as I mentioned, we have seen cases in the past that have gone on for several years. I want to give a couple of statistics, if I may, with the indulgence of the board, of the committee. Between September 1st, when we started internally tracking these cases on a centralized basis, between September 1st and December 31st, we processed 646 cases. Since January 1st of this year, and up until yesterday, we have processed 195 open cases. Without this change in legislation, each board has their own processing system for complaints. By having this language in the statute, it will allow us to continue to flow through a centralized system, which again benefits the protection of the public health, safety, and welfare, but also balancing the licensee's due process rights. At this point, I also want to stress emphatically something Senator Reagan said. By changing this complaint investigation adjudicatory process, every single board retains the same regulatory and statutory oversight of their individual professions. There is no diminished authority on the board. With the indulgence, I'm not sure, we have our Chief Administrative Prosecutor. I think she is scheduled to speak. Her name is Rakia Medley. I don't know if it would make sense to have Rakia speak right after me or if there's a specific order. But thank you very much.
Thank you very much for your testimony this morning, Mr. Porter. Are there any questions from the committee? Okay, seeing none. Mr. Porter, how involved were the boards in this process?
That's a great question, Senator, Chairwoman. I have personally, along with the executive director, have gone in to meet with just about every board right now to discuss the process. And we are in the process of having each board review the standing order, which it outlines the complaint process from beginning to final adjudication. And we are still waiting for boards. They wanted an opportunity to review it because they meet once every 30 days. The process is a little slow, but we have a number of boards who have signed on.
Okay, thank you. Are there any additional questions? Okay, seeing none. Thank you very much.
Thank you, Madam Chair.
Okay, next we are going to go to Douglas Osterhout.
Douglas, you should be able to unmute yourself.
Can you hear me now? Can you hear me now?
Yes, we can.
Good morning. My name is Douglas Osterhout. I'm an attorney with DHHS. DHHS today on Part 9. I also have with me Bureau Chief Wendy Altman. She's the Bureau Chief of Elderly and Adult Services. We were planning, if possible, to be able to testify together. I'm going to give the bulk of the testimony, but Wendy is here to answer programmatic questions if there are any.
Okay, that's fine. The two of you together. It's just when you speak to identify who you are, so that way our committee secretary can make sure that they capture the right person saying the right thing.
Absolutely. Yeah, it's difficult in these times. Thank you. So I just want to point out that a fiscal note worksheet was delivered to the LBA yesterday, but we are here to talk about and object to Part 9 and request the removal of Part 9. Senator Reagan sponsored SB 49 in 2015, and the purpose of that was to change the language identifying who was permitted to determine clinical eligibility under RSA 151E3 from registered nurses to skilled professional medical personnel. Okay, that the department requested the legislation and we testified in favor of the change. It was going to broaden the scope of individuals permitted to conduct clinical eligibility assessments and issue determinations. So for example, it would allow an APRN or an LPN to conduct those assessments. It would allow us to fill key positions, avoid delays in the provision of services to the citizens of New Hampshire. Prior to that change, so I just want to point out, currently we do have 3 RNs in the position to make those decisions. But prior to that change, the limiting language had at certain times placed the department in the position of being unable to fill the roles of those tasked with issuing determinations, which in turn led to delays in issuing decisions, which in turn led to delays in services. It's also worth noting there is a recognized shortage of registered nurses throughout the state, and even hospitals are struggling to find adequate nursing coverage for those in res care, those in individual homes. Also the language in proposed paragraph 3A, I'm just sort of going down through the bill in the order it was presented in Part 9, would require skilled professional medical personnel to oversee service coverage prior authorizations for Medicaid home and community-based care waiver services. So it isn't necessary to meet the definition of a skilled professional medical personnel in order to administer or supervise staff of a program in which staff render determination. Okay, this language singles out the department and department staff who administer the home and community-based care waiver services and places restriction on program administrators and supervisors beyond those required for similarly situated entities. So for example, there's no requirement that an administrator or supervisor in a nursing facility meet the definition. And we confirm that with the Office of Professional Licensure, that non-clinical personnel may supervise clinical personnel. It's the licensee who's responsible for that clinical decision. Additionally, in my conversation with OPL, they pointed out that there's no specialized training, including for registered nurses, that would provide the trainee with administrative or supervisor capabilities beyond those of administrators or supervisors who have not undergone training as an RN. The part of 151E3(3)A, limiting those permitting to render adverse service coverage determinations to only skilled professional medical personnel who are registered nurses. That would require the department to devote medically trained staff to render adverse determinations for requests that may be denied for non-clinical reasons. So an example of that would be an incomplete application or a failure to exhaust third-party liability. So denials like those don't need specific skill set of a registered nurse. They're programmatic in nature, they're administrative in nature. I want to talk about the definition real quick too. So the language of proposed paragraph 5 defines skilled professional medical personnel as having the same meaning as 42 CFR section 432.2. There is that exception which carves out the employer-employee relationship. So while the employer-employee relationship is the only explicit exception to the definition found in 432.2, the requirement that only registered nurses may render adverse clinical eligibility or service coverage determination creates additional exceptions to that definition, which includes, these are examples from the CFR, includes as skilled professional medical personnel, physicians, dentists, nurses, other specialized personnel who have professional education and training in the field of medical care or appropriate medical practice. So these additional exceptions, limiting it to RNs, results in the definition of skilled professional medical personnel under RSA 151E3 being more restrictive than the federal definition and places additional restrictions on who may render adverse determinations. So under the current more encompassing definition that we have in place, someone like a licensed practical nurse, again, would be able to submit one of those adverse decisions. The proposed definition would not allow that to happen. And I'd also like to point out, this was pointed out to me by OPL, that a licensed practical nurse is also covered under RSA 326B, which governs registered nurses. Again, when SB 49 was introduced in 2015, a subcommittee of the House Health, Human Services, and Elderly Affairs Committee worked really hard over the course of at least 2 work sessions on the definition of skilled professional medical personnel. And they came to the decision then in 2015 to remove the reference to 42 CFR section 432 under the belief that inclusion of 2 CFR definitions for the same term as is currently proposed would lead to confusion. The subcommittee also decided to go with 42 CFR 432.50 D1 2i for its reliance on the use of the term professional education and training. And this morning, Senator Ward mentioned something about the FFP, so the federal participation for skilled professional medical personnel. And as long as those conducting assessments, and this was also one of the reasons it was chosen to be the way it is currently, they have to meet the definition of professional education and training found under 432.50 in order for us to get the 75% match from CMS. There is no requirement for waiver service authorizations. So I know that was a lot. I tried to go quickly to respect your time. Happy to take questions.
Okay, thank you very much, Mr. Osterhout. Ms. Altman, do you have anything you'd like to add to the testimony?
Good morning, Chairwoman Carson. No, I don't have anything to add. I'm here to be able to be supportive of any questions that you may have. Thank you.
Okay, thank you very much. Are there any questions from the committee?
Senator Reagan has his hand raised.
Okay, Senator Reagan. could you let him know that he's recognized?
Senator Reagan, you have to unmute. There you go.
There you go.
So in the testimony, he kept referring to CFR, and that's jargon. And I wish he would define his term better so that everybody would understand.
Okay.
My apologies. So this is Douglas Osterhout speaking. When I refer to CFR, the definitions we're talking about are 42 CFR section 432.2 and 42 CFR sections 432.50 and additional letters. But CFR stands for Codified Federal Regulations. It's essentially the rules of the federal government.
Thank you.
Okay, that's good to know. Okay, are there any further questions from the committee? Okay, seeing none, thank you very much for your testimony this morning, Mr. Osterhout and Ms. Altman. Okay, next we're going to go to Thomas Broderick.
You should be able to unmute yourself.
Great, thank you very much. Can you all hear me?
Yes, we can.
Good morning, Madam Chair and members of the committee. For the record, I'm Tom Broderick, legal counsel at the Office of Professional Licensure and Certification, or OPLC. The OPLC provides administrative and clerical support, record-keeping services, and business processing for the 54 occupational licensing boards, commissions, and councils under its umbrella. I'm here now to speak on sections 12 and 13 of SB 133. First, I'd like to speak now on section 12. This begins on the bottom of page 49 and ends on page 51. This portion of the bill affects the Board of Barbering, Cosmetology, and Aesthetics. I first want to make clear that while we've consulted with the board throughout this process and they're aware of this proposed legislation, I'm speaking today on behalf of the OPLC, the agency only. I'm not speaking on behalf of the board. So OPLC requested this change after consultation with the board, really to fix and or clarify two technical issues with the Board's Practice Act. Both issues concern the board's authority to regulate programs within high schools. So the board currently licenses independent schools, say Tom Broderick School of Barbering. It also licenses barbering and cosmetology programs within high schools. So for instance, Concord High School has a cosmetology program where students can get an apprentice license from the board and learn cosmetology at the high school. The first issue that this legislation is seeking to resolve is clarification as to whether the board has the authority to license and regulate the programs within high schools rather than just independent schools. As I mentioned earlier, the board currently does so and has done this for a long time. The confusion has come from a discrepancy between the definition of school in RSA 313A1-12, which is broad and reads, school means a school or other institution conducted for the purpose of teaching cosmetology, manicuring, barbering, or aesthetics. And language in RSA 313A7-2, which reads, the board may license a school to operate post-secondary programs, including post-secondary programs leading to a certification in barbering, cosmetology, and aesthetics. So this bill on pages 49 and line through 15 of page 50 is seeking to clear this, that the board does have the authority to license programs within schools as well as post-secondary programs, which the board is currently doing and has been doing as long as known. The second issue the legislation is seeking to resolve is a bit more complicated. So under the Child Protection Statute, which is RSA 161B11, 6A, OPLC and any state agency is required to collect the social security number of any applicant for a professional license. But for these students in the public high schools, I believe it's under FERPA, the Federal Education, I should know what that stands for, but the Federal Education Law. I believe the school cannot require a student to provide their social security number. So we have a bit of a catch-22 where the school cannot request a social security number, but the board must require it. The remainder of this bill, page 50, line 16 through the end of page 51, line 3, is meant to fix this issue. So In short, this bill would exempt those applying for apprentice certificates from the requirement to provide a social security number. Full licensees would still need to require the social security number, but the apprentice certificates, those applying for apprentice certificates would not. That concludes my testimony on section 12. I'm also speaking on section 13, which begins on the bottom of page 49 and ends on page 51. So this portion of the bill affects the Board of Psychologists. Again, I want to make clear I'm speaking on behalf of the agency only, not on behalf of the board. I believe a board member, Dr. Warner, is here to testify either on her own behalf or on behalf of the board. So OPLC is neutral on this piece of legislation. However, we do have some concerns that I briefly want to make the committee aware of. This piece of legislation would create a new license category, New Hampshire Telehealth Pass. And I understand the intention of which is to allow out-of-state psychologists an easier way to provide psychologist services via remote technology into New Hampshire. So there are currently two ways individuals from another state can provide telepsychology services in New Hampshire. First, they can go through the regular licensure process and simply get a license here in New Hampshire. Or second, New Hampshire has joined the Interstate Compact, SIPACT. We joined in, I think, September 2019. So if their home state is also a member of SIPACT, they can obtain an Interstate Compact license and then practice here in New Hampshire. OPLC's concerns here are twofold. So as I mentioned earlier, it creates an entire new license category. This is not an insignificant administrative burden on OPLC. It involves granting a new set of initial applications and renewals. It also requires OPLC to work with the boards and draft rules on this new license type. OPLC, we're not necessarily against the bill for this reason, and we of course will implement it if the bill is passed, but we wanted to make the committee aware of this. The second concern dovetails with this. The board joined the Interstate Compact in September 2019, less than 2 years ago. 14 states have joined and are active in the compact now. One more has joined, but the legislation is not yet effective. And 13 more states have pending legislation this year. So that's a total of 28 states. From what we've seen with other compacts, the number of states that have joined will only increase in the near future. For licensees coming from these compact states, this bill is unnecessary and redundant and may actually be more confusing to individuals looking to practice telepsychology in New Hampshire. Admittedly, it's not redundant for those coming from non-compact states. However, as I pointed out, we anticipate more and more states joining the compact. Lastly, I was aware of this potential bill earlier in the fall. The board had discussed it at a meeting where I was present. My understanding then was that it was being put forward due to a potential disagreement with SIPACT, the compact commission. However, that issue has since been resolved. But my understanding now is the board still wants to move forward with it, and Dr. Warner can testify as to that a bit. This concludes my public testimony. I'm happy to take any questions.
Thank you very much for your testimony this morning. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Rakiva Medley.
Rakia, you should be able to unmute yourself.
Thank you. Good morning, Madam Chairperson and committee. My name is Attorney Rakia Medley. I'm the Chief Administrative Prosecutor at the Office of Professional Licensure and Certification in the Division of Enforcement. I'm here to speak in support of Section 8 of Senate Bill 133, which was LSR 2021-899. This will ensure consistency and efficiency in the complaint investigation and disciplinary processes, as well as other administrative duties. This will not diminish the authority of the boards, councils, and commissions within OPLC. Providing a uniform system to the public allows for a centralized, consistent, and efficient ease of access to each regulatory board when members of the public have complaints and concerns. Important functions of the OPLC are balancing the protection of the public health, safety, and welfare of the citizens of New Hampshire while providing due process to licensees. Streamlining processes within the OPLC assist in balancing the scales and shortens the time between any complaint that is filed with the OPLC and adjudicative proceedings resulting in a decision from the board, council, or commissions. Section 8 codifies the process that has been put in place, which Mike Porter has described earlier, and which has been in practice. Because of this, the OPLC has successfully been able to receive and handle multiple emergency complaint matters involving drug diversion, vaccine diversion, responding to a complaint involving a licensee that allegedly picked up a child by the ankles, and most notably a major nursing school that, again, Michael Porter spoke about earlier. This also will provide a way to efficiently respond to non-emergency complaints. The emergency matters were received and were responded to within days, and in some cases, even hours of receipt. Having the OPLC function in this way has provided the agency with the ability to fulfill its intended purpose, which is to promote efficiency and economy in the administration of the business processing, record keeping, and other administrative and clerical operations of professional licensing and certification boards, including both professional healthcare licensing and professional technical licensing, which is outlined in RSA 310-A:1. Section 8 of Senate Bill 133 further promotes this purpose, while the boards, councils, and commissions retain the same regulatory and statutory oversight over their individual professions. And thank you. If you have any questions that you would like to ask, I'm here to answer them.
Senator Carson or Senator Reagan, are either of you there?
Yes.
Senator Carson stepped away, so you have the gavel. Oh, Senator Carson.
Yeah, I'm back. I'm sorry. My daughter is currently hospitalized, and her doctor is on the phone. I'm going to put the committee in recess for 10 minutes. Thank you.
Nobody else can do anything. Right. Bitch.
Hey, Cam.
Hi, Senator.
Yeah, sorry about that. Hospitalizations in the age of COVID. So I had to talk with the doctor. They're going to be doing a procedure on my daughter this morning. So I've got to, had to talk to him. So, okay. People can hear me. That's okay. I just had to step away very quickly to speak to the physician. So, okay. Did Attorney Medley finish her testimony?
She did.
Okay. Did you happen to note the time, Cameron?
It was 10:33.
Okay. Okay, we can probably go ahead and get started again. Okay, I'm going to take the committee out of recess. I apologize. Some of you have heard my daughter is currently hospitalized and her physician called and I had to take the phone call. So I ask for your indulgence and thank you. We're going to go ahead and finish hearing from folks on Senate Bill 133. And we're going to go to the next person to testify, which is Paul Parisi.
Fire Marshal Parisi, you should be able to unmute yourself.
Thank you, Aaron. Good morning, everybody. Madam Chair, can you hear me okay?
Yes, we can.
All right. Good morning, Madam Chair, members of the committee. Madam Chair, I'm sorry to hear about your daughter, and I wish her.
Oh, thank you.
My name is Paul Parisi, and it's my privilege to serve as your state fire marshal. I'm here this morning to testify in support of Senate Bill 133, Parts 1 and Part 2. I'll begin with Part 1, which we asked Senator Carson to sponsor. And Part 1 enables the New Hampshire State Fire Marshal's Office the ability to issue a place of assembly license in the event it is necessary to do so. Currently, New Hampshire Statute 155-18 requires that places of assembly are licensed to operate. Places of assemblies are rooms or spaces where 100 or more people congregate, 50 or more if the space happens to be a tent. Currently, a license is issued by the city, town, or village district where the occupancy is located. This creates a problem where the assembly is located in an unincorporated area, such as Greens Grant, the summit of Mount Washington, or an area that does not have an authority having jurisdiction for the purposes of fire prevention, such as the Balsams at Dixville Notch. This bill would allow the State Fire Marshal's Office to be the licensing agency in those cases and in other unusual cases when we consult with the local licensing agency. I thank you for the ability to testify. I will certainly be happy to answer any questions on Part 1. And then on Part 2, I would simply offer my support. And as Senator Guida noted, there's currently a move to perhaps strike a section that the rules would occur without our consultation or consent. And currently we are in the loop on that. Taking us out is fine by us, and that is consistent with a move to actually move the mechanical licensing board over to OPLC, and that is something that I think you'll see in the governor's proposed budget. So thank you very much. Be happy to answer any questions.
Thank you very much for your testimony, Chief. Are there any questions from the committee? Okay, seeing none, thank you very much. Okay, next we are going to go to Colleen Smith.
Colleen, you should be able to unmute yourself.
Good morning. Thank you, Senator Carson and members of the committee. My name is Colleen Smith. I'm with the administrator for the food protection section within DPHS of the Department of Health and Human Services. And I also want to note, I do have with me today Michelle Roberts. She is the Bureau Administrator within DPHS in Health and Human Services, and she is here to also assist with any questions that you may have, although I will be speaking primarily to Section 14 of this bill.
Okay, before you get started, just because we will recognize both you and your colleague, is that when you speak, just identify yourself so that way our secretary can make sure to the comments are correct. Okay?
Thank you, Madam Chair.
Thank you.
We want to thank the committee for the opportunity to speak on Section 14 of the bill. The department has had several constructive conversations with Senator Gaida beginning in the spring of 2020 regarding his concerns related to the department's food protection regulations, in particular the Certified Food Protection Manager requirement. And we've been working very diligently with him on a regulatory solution. While our testimony today focuses on the department's serious concerns with this part of the legislation as introduced, we would like to note that we have met with Senator Gaida as recently as yesterday and are in the process of reviewing the proposed amendment to this legislation. The department is also engaged in rulemaking process to address the concerns brought forth by Senator Gaida, and we're committed to collaborating with Senator Gaida to expeditiously address his concerns. So in summary, this part of the bill would codify the department's rules for the sanitary production and distribution of food, which is HEB 2300, into law. And so this would repeal the rulemaking authority of the commissioner in the food licensure section, RSA 143A9, the homestead food operations, which are codified in RSA 143A13, and the sale of uninspected poultry and rabbits, which is codified in RSA 143A17. To provide some background, the New Hampshire rules for the sanitary production and distribution of food were updated in August of 2019 to incorporate the 2017 version of the food code, which is the latest model food code based on the latest science into its administrative rules. We did do extensive stakeholder outreach, which is a year-long process prior to implementation of the rule. This included looking at that certified food protection manager requirement, which was to be a part of the new rule. And to provide some background on what that is, that means the person in charge of the food establishment has to have demonstrated proficiency in passing a class in food safety. This is generally an 8-hour class with an exam, and there are currently many entities in New Hampshire that offer this class, including UNH Cooperative Extension, New Hampshire Lodging and Restaurant Association, and HR Food Safe. But there are many other providers that can do this training online and in person to New Hampshire food service workers. So when we did our outreach, we found out that almost half of food establishments already had at least one certified food protection manager on staff already. We also had done extensive stakeholder outreach upon passing of these rules, which included 6 trainings located in different regions of the state, and an online version, which is still posted on the department's website. Senator Gaida had brought forth to us in April of last year a concern with one particular business's hardship with complying with this rule. We did work very closely with this business to create an alternative through a variance to achieve the same public health, addressing the same public health protective measures within this variance, but also to relieve that economic hardship for this business. And we are also working to amend our rules to make it easier for smaller businesses to comply with this section of the rule that have minimal food preparation, so that there wouldn't be public health risks associated with implementation of this rule. Also, I would like to note that there is a requirement in this bill for the department to offer the certified food protection manager training. We addressed this in a fiscal note that was sent to the LBA on the 8th of February. So we would envision that we would need at least one trainer to provide this training, and there would also be indeterminate costs associated because we would not know how many employees and employers would take advantage of this state training. Although we would be supportive of being able to offer this training, we do recognize there would need to be an appropriation for this. The department noted many technical defects and mechanical defects identified within this legislation. We believe that the amendment might address some of those, but we find that due to, as was mentioned before, this is a difficult time for the food industry. We feel that the easiest and most expedient way is to address this in rulemaking versus legislation due to the number of mechanical defects that would have to be overcome by placing a rule into statute. With that, and also I want to note there was some mention about concerns about plumbing, septic, and building code requirements. We had been focused on remedying the certified food protection manager requirement, but we would be happy to work collaboratively with Senator Gaida and others to work on solutions for those issues as we could get more understanding of those. So with that, I would conclude my testimony and be happy to answer any questions that the committee may have.
Thank you very much for your testimony. Are there any questions from the committee? Senator Prentice.
Thank you, Senator Carson. Colleen or Michelle, thank you very much for your testimony this morning. Just for a point of clarification, so you've been working closely with Senator Gaida, and I understand the complexities of putting a volume of administrative rule into statute. Are you close enough to a solution where we can, see different language, or you won't need this bill? I mean, and that might be partly for Senator Gaida as well. I just heard about some of the conversations happening back and forth. I'd like to avoid putting rule and statute if possible, but I'm curious or want to just know what the future looks like in the short term.
Sure, I would be happy to answer that as best as I can. I believe that we have worked through some language that would address the certified food protection manager requirements. I'm not exactly familiar with the breadth of the other concerns that were mentioned regarding plumbing septic codes, but we would be happy to delve into those particular issues with Senator Gaida and others to see if we could incorporate those changes into our rule as well.
Thank you, Colleen. Senator Carson, I'm all set for now.
Okay, thank you. Are there any other questions from the committee? Okay, I'm just, you had mentioned the section that dealt with the plumbing. Are you speaking to part 2, establishing a limited plumbing specialist license?
No, I was not referring to that section of the bill. It's there was some mention in the amendment that there were some changes to implement plumbing code references for food establishments.
Okay, all right. So I thank you for answering that question. I just want to make sure that that you are actively working with Senator Gaida to resolve these issues.
Yes, we are committed to doing so.
Okay. All right. Thank you. Does Ms. Roberge have anything she'd like to add at this point?
Thank you, Senator Carson. No, I'm all set. I'm just here to help answer any questions.
Okay. Thank you. Thank you both very much for your testimony this morning. Next, we're going to move on to Lindsay Courtney.
Lindsay, you should be able to unmute yourself.
Thank you. Good morning, Madam Chair and members of the committee. My name is Lindsay Courtney. I'm the Executive Director of the New Hampshire Office of Professional Licensure and Certification, which is the agency that administers the 54 occupational licensing boards in the state. I wish to offer testimony on parts 2 and parts 4, but I am happy to answer any questions that impact the agency regarding the matters that we heard today. OPLC wishes to express its support of parts 2 and parts 4 of this bill. Part 2 establishes a limited plumbing specialist license. As we heard earlier, the purpose is really to permit individuals to qualify for a limited license earlier in an apprenticeship. Essentially, apprentices would be able to provide certain services for which they are qualified as they demonstrate competency as determined by the Mechanical Licensing Board. This bill really is consistent with the national trend towards stacking occupational licenses to promote workforce opportunities while ensuring the public is adequately protected. And as such, OPLC supports Part 2 of this bill. Should the Mechanical Licensing Board be transferred to OPLC, OPLC would welcome the opportunity to support the board in its rulemaking and administrative obligations under this bill. Part 4 removes the prohibition in RSA 326B38 of public members of the board serving as the presiding officer over disciplinary hearings. The Board of Nursing is the only board of our 54 boards within the office that does not permit the public member to preside over hearings. The Board of Nursing has specifically requested this legislation to standardize requirements across the agency and to permit all members of the board to serve the state in this capacity. The presiding officer of disciplinary hearings essentially just controls the flow and conduct of the hearings and rules on evidentiary motions. The presiding officer does not have authority to make decisions regarding disciplinary matters on behalf of the board. That authority remains with a quorum of the board. A quorum of the board must be present to adjudicate all cases, and all board members have the same authority to ask questions of witnesses. The presiding officer simply facilitates communications, much like a chair of a committee. During last session, we heard testimony that some nurses were concerned about a non-nurse presiding over a hearing. However, I believe these concerns are based on the belief that the presiding officer has authority over the outcome of the proceedings. As noted, the presiding officer has no more authority over the outcome of the proceedings than other board members. And OPLC supports this bill as it brings the Board of Nursing in line with the other boards and permits all board members appointed by governor and council to serve the state in the same capacity. I'd be happy to answer any questions regarding these parts or any other parts, including 2, 4, 6, 8, and 12, if you have any questions. Thank you.
Thank you very much for your testimony this morning, Ms. Courtney. Are there any questions from the committee? I just would like to ask, are the boards all in agreement on section 4? Because Mr. Donovan, who testified, gave us some pretty very detailed information, which I think was very, very helpful about the process and how it's been working and how there's been really a lot of delays. And we really don't want to see that, especially if it's a complaint has been made against someone's license. So I just wanted to know whether or not the boards are in support of this as well.
On section 8 regarding, I think it's LSR 899, was that your question, Senator Carson?
No.
Yeah, so,
okay. No, I'm sorry. Go ahead. I'm sorry.
Yeah, we've been collaborating with the board since about August to come up with a standardized procedure within our existing framework. So a lot of the boards have been adopting and agreeing to promulgate standing orders, permitting us to standardize the process. I don't have the exact number of boards that have essentially signed on. We do have a number of boards that have, including the Board of Nursing, the Board of Mental Health Practice, I believe, Midwifery Council, Psychology has not, medicine we're working with, a number of the tech boards. Essentially, it's taken time for us to go to all of the boards and present this information to them and give them an opportunity to sign on. But our hope and expectation is over the next couple months, we'll get the large majority of boards on board. I think as boards have seen that the process works and that we are able to reduce the time frame for complaints and investigations, as well as reduce the time frame to notice of hearing, more boards are willing to sign on and try it out. So it is a collaborative effort.
Okay, thank you for that testimony. Do the committee members have any questions? Okay, seeing none, thank you very much.
Thank you.
The chair is going to call Tina Kelly.
Tina, you should be able to unmute yourself.
Good morning, Madam Chair and members of the committee. I'm Tina Kelly. I work in the Office of Legal Counsel for the Office of Professional Licensure and Certification, OPLC. I'm here today to speak on sections 6 and 7 of the bill. And I will start with section 6, which is on compacts. OPLC is in support of the two compacts, speech language pathology and audiology, and the occupational licensure compact. These compacts will allow for mobility between states while keeping all safeguards in place and continuing to be able to investigate individuals with compact privilege and take disciplinary action when necessary. Ensure standards requirements for licensees across compact states. Those requirements include standardized education, examination, verification of licenses they may have held in other states, background checks. They would only have to submit these documents in their home state, and then based on those evaluations, they would be able to get compact privileges in the other compact states without having to resubmit all these documents. It allows for cooperation and communication across state lines, especially when it comes to investigations. We'd be able to share information with somebody, especially in New Hampshire where we're so close to the other borders, share information with a compact state that may be right next door, that the investigations may impact both states. An individual who holds license in a member state will be issued the privilege to practice in another member state. Those individuals holding a privilege to practice are required to follow the scope of practice in the state where the patient or client is located. In addition, the individual holding the privilege to practice is subject to all the laws and rules of the state in which that individual, that the patient or client is located. The PT board a couple of years ago joined the PT compact. It's very similar to these two compacts, and it is working extremely well. Even though none of our surrounding states are part of the compact, we do have individuals coming from a number of other states weekly to practice here, a lot on temporary basis as facilities need these individuals. The next section I want to testify on is section 7, music therapists. The Office of Professional Licensure and Certification does not support nor do they oppose this bill. They do, however, want to bring forward a couple of concerns they have with the language as it's written. The first one is on page 38, line 30. It adds the definitions listed to RSA 328. These definitions should only be in RSA 326M if this piece of legislation goes forward. Adding all of these definitions to the allied health definitions will change some of the definitions for all the boards. And it's already, the definitions in the allied health law are already addressed on page 40 in line 35. So adding these first definitions is not necessary. Number 2, the board is being added to the allied health boards, which are fully autonomous boards receiving administrative support from the Office of Professional Licensure and Certification. On page 40, line 33, it states, Roman numeral 3, the executive director shall seek the advice of the board for issues related to regulation of music therapists. Because this requirement is there, it's unclear whether this is an autonomous board or an advisory board to OPLC. And then lastly, I'd like to say on page 47, line 27, there is a new position created if this were to pass. And I'd like to say that if this does pass, OPLC would definitely need an additional position. even though the numbers of these individuals is not great, there's a lot of administrative work that goes with any board, no matter how large or small. And so I'd like to make sure that we encourage that this be left in if this should pass. That concludes my testimony, and I can take any questions if you have them.
Thank you very much, Ms. Kelly, for your testimony this morning. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Okay, next we're going to go to Marissa Scott.
Marissa, you should be able to unmute yourself.
Yes. Hello.
Good morning.
Good morning, Madam Chair and members of the committee. Thank you. I'm Marissa Scott, and I'm here to support Part 7 of this bill, Senate Bill 133. I'm speaking to you today as chair of the New Hampshire Music Therapy Task Force, also a female business owner and a board certified music therapist in the New Hampshire system. I have 5 employees in my business providing music therapy services to over 2,500 individuals in New Hampshire. And I'd just like to highlight 2 important points on the necessity of this bill. The first, increasing access to services, and the second, protecting consumers from harm. So people seek music therapy for many reasons to work on personal goals in areas such as emotion, regulation, sensory integration, and self-expression. And just one example, through the combination of a therapeutic relationship, songwriting interventions, and consistent work in music therapy, I've helped a teen with depression cease and prevent himself from continuing acts of self-harm. And I'd also like to point out that another person who is testifying today will give you more of the background on our clinical education and training. But many people face some bureaucratic barriers preventing access to music therapy services. You see, private insurance companies require the provider's license number on the credentialing form for reimbursement. And despite hundreds of calls, I've been told repeatedly that we can't bypass this request for a license number. Medicaid also has the same requirement, and with over 27,000 disabled individuals enrolled who can't access services from unlicensed providers. And that number doesn't even include abused and traumatized children who have been placed in foster care. Yet referrals from licensed doctors and social workers who know the efficacy of music therapy continue to come in for patients in need who can't access our services. I'm not asking you to advocate on our behalf to private or state insurances or get involved in the reimbursement processes, and insurance reimbursement is not the intent of this legislation, but it is imperative that you know all the barriers that New Hampshire consumers are facing. And also, to my second point, it might seem hard to understand how music could cause harm, but I would like to explain. So music therapists are explicitly trained to observe and respond to a person's responses to music. We continuously assess their responses, and we adapt our approach in the moment to refrain from any contraindicated practices. So given the diversity of diagnoses we work with, comprehensive and rigorous clinical training and experience are necessary. And anyone attempting to provide music therapy without the training and credentials that board certified music therapists have may pose serious risks to consumers. An example of such harm would be using music that's too complex for someone's neurological system, resulting in agitation, dysregulation, and possible seizure. There's also the potential of music to be triggering for clients who've experienced trauma or disorienting for clients with Alzheimer's. Ineffective or lack of trained therapist responses can lead to short and long-term psychological and even physiological harm. And in New Hampshire, we have individuals claiming they provide music therapy to these vulnerable populations, yet they are not educated, clinically trained, or board certified. No one regulates their compliance with safety standards that board certified music therapists are required to comply with. Creating a state license mandates individuals meet both state and national standards when identifying themselves as music therapists to consumers and protects the most vulnerable citizens. So I urge you to vote yes for this Part 7 of New Hampshire SB 133. And by doing that, you're increasing access to the medically necessary evidence-based services that music therapists provide and protecting constituents from the potential of harm that could be caused by an untrained person. Thank you for your support. And also, if I may add that this part of the bill does have some history, and I would be happy to share that with you if you are interested.
Thank you very much for your testimony this morning. Are there any questions for Ms. Scott? Okay, seeing none, thank you very much. Next, we're going to call Brendan Williams.
Brendan, you should be able to unmute yourself.
Thank you, Erin, and thank you, Madam Chair and members of the committee. Best wishes with your daughter, Madam Chair. For the record, I'm Brendan Williams. I'm the President and CEO of the New Hampshire Healthcare Association. We represent most of the state's nursing homes and many of its assisted living facilities. Testifying in support of Part 10 of the bill, which was introduced by Senator Hennessy and then incorporated into the bill by you, Madam Chair. And, you know, I think everyone in this committee is aware of the toll that COVID-19 has taken upon nursing homes and nursing home staffing. We had a shortfall even prior to the pandemic in terms of our ability to retain staff. There was a Board of Nursing statistics that we requested that showed that there had been a net loss throughout the state, not just specific to nursing homes, of over 1,000 licensed nursing assistants over a 2-year period of time. And that just simply made matters worse during the pandemic. There was a federal waiver that was granted that most states utilized, including New Hampshire, to allow for temporary nurse aides to assist in nursing homes. Here in our state, we call them temporary health partners. This was a process that was heavily negotiated before the executive order was issued. And what this part of the bill would allow would be to count the experience of those temporary health partners towards becoming a licensed nursing assistant. We're probably talking about a small population of potential LNAs through this, perhaps just a couple hundred, but I think you would find in talking to your constituent nursing home providers that the temporary health partners have been really invaluable, particularly in situations in which staff are out on quarantine, either because they're presumptively ill with COVID-19 or have been identified as ill with COVID-19. And so those temporary health partners have been really of assistance. And their experience, I think, in these most trying of circumstances should count towards becoming a licensed nursing assistant, if that is what they choose to do. And very oftentimes what we found is that the people stepping up to be temporary health partners were already working within the facility, perhaps in housekeeping, perhaps as dietary. So that's what the bill would do. It would give the Board of Nursing tools to be able to count that experience towards becoming a licensed nursing assistant. And if you should have any questions about that, I'm happy to take them. Urge your support.
Thank you very much for your testimony, Mr. Williams. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Next, we are going to go to Rebecca Gildea.
Rebecca, you should be able to unmute yourself.
Thank you. Madam Chair, members of the committee, my name is Rebecca Gildea. I'm a board-certified music therapist living and working in New Hampshire, and I am speaking to Part 7 of this bill relative to the licensure of music therapists. And I thank you for the opportunity to speak in support of SB 133. I'm going to testify on the education and experience of music therapists. Today, there are at least 40 music therapists working in the state of New Hampshire. That may sound like a small number, but the impact of just those 40 music therapists is significant. In 2019, New Hampshire music therapists worked in 67 different facilities and served at least 2,841 individuals across the Granite State in settings such as early intervention, special education, day programs, memory care, behavioral health units, eating disorder clinics, and substance use programs, to name a few. Music therapy is an allied health profession similar to physical, occupation, or speech therapy. A board-certified music therapist utilizes music-based interventions to address social, emotional, physical, communicative, and cognitive domains on an individualized basis. Music therapists use evidence-based practices to work toward each client-centered goal, supported through a body of research spanning decades. The evidence of the positive effects of music therapy has grown so much that the National Institutes of Health has awarded $20 million toward research on music therapy and neuroscience over the next 5 years. Some things you might see in a music therapy session include songwriting and lyric analysis, instrument playing, music and movement, or improvisation, each designed to address a client's specific goal, such as making an emotional connection to peers for older adults with Alzheimer's, or increasing emotion regulation for a teen struggling with anxiety, or crossing the midline for a child with autism, or learning healthy coping skills for adults with substance use disorders. The education, training, and certification of a music therapist is expansive and rigorous. A music therapist must earn a bachelor's degree or higher, the curriculum including coursework in music, human development, psychology, anatomy and physiology, and the behavioral sciences. Through this diverse course of study, a student learns how to use the elements of music, the relationship between the therapist and client, and the act of musicking itself as a means of meeting specific, measurable, and appropriate goals for their clients. After their classes, a student must earn a minimum of 1,200 hours in supervised clinical experience at an internship site. At the completion of their academic and clinical training, students are eligible to take the board certification exam to earn the credential Music Therapist Board Certified, or MTBC. To demonstrate continued competence and maintain this credential, music therapists are required to complete 100 hours of continuing education every 5 years. These standards are in line with our colleagues in the allied health professions. Music therapy is an established, evidence-based, and efficacious practice that is serving the citizens of the Granite State. But our profession faces barriers to services due to lack of licensure. By creating a state license for music therapists, you will be the governing body that upholds our high standards of practice, thereby protecting your constituents from non-certified practitioners, meaning people stating that they are doing music therapy without being board certified, who do not have this body of experience and education. In addition to this protection of the public, you will be creating a state standard that is comprehensive and accessible, ensuring a transparent process for New Hampshire citizens to find a qualified and licensed music therapy provider. Finally, you will be removing barriers to much needed services, recognizing music therapists in the state alongside their peers in related professions, and providing an avenue for job growth throughout the state. For example, since Rhode Island, which is among 12 other states that have licensure, and an additional 15 states with proposed legislation, since they have passed music therapy licensure in 2003, the growth of music therapists in Rhode Island has increased significantly. Jobs have been created, and the amount of citizens accessing music therapy services has increased. The field in Rhode Island has grown so much that there's now a degree program for music therapy at their state university. We believe New Hampshire would have a similar experience with growth in our state with increased access to services throughout, through the implementation of state licensure. Today, I share my support of SB 133, specifically Section 7, and ask you to vote yes for music therapy licensure in New Hampshire. Thank you.
Thank you very much for your testimony this morning. Are there questions from the committee? Seeing none, thank you very much. Next, we're going to call Paula Minahan.
Paula, you should be able to unmute yourself.
Yes, thank you. Good morning, Madam Chair and members of the committee. I'm assuming you can hear me. If someone
yes.
shakes it. Thank you. For the record, Paula Minahan, Senior Vice President, State Government Relations with the New Hampshire Hospital Association, representing all our hospitals in the state. We're testifying today on only two parts of Senate Bill 133, Sections 4 and 13. And I won't, you have my written testimony, so I will be brief. I know you're very busy this morning. We are supportive of Part 4 relative to the Board of Nursing. As Executive Director Courtney indicated and others, we believe that this is appropriate, and she reiterated why that is. So again, I will not repeat that. So we are supportive of that. We are concerned about Section 13, which is specific to telemed provided by out-of-state psychologists. We're concerned because of the kind of the macro perspective, that we are concerned with any changes made to the telehealth law, which was just signed into law by the governor last June. It's our position that the commission to study telehealth services is the appropriate venue for any potential modification of the telehealth statute to be considered. So we're not specifically concerned about this particular change, except it's kind of we believe a kind of a slippery slope potentially, and what that could possibly do to other clinical boards. And we just have a lot of concerns about that without really understanding exactly what telepass license is. It's undefined as far as I could tell from looking at the bill. And again, we're worried about that potential that impacts other professions like physicians who actually, the law requires a face-to-face visit before, except with certain very specific exceptions that were put into law last year regarding MAT and the Veterans Administration, et cetera. So we are not supportive of that section due to those concerns that we have. And thank you for the opportunity to speak, and I'm happy to answer any questions. Thank you, Madam Chair.
Thank you very much for your testimony, Ms. Monahan. Senator Prentice has a question for you.
Good morning, Paula. Nice to see you, hear you again. Just in case I missed this. So you have a concern with the telehealth part of it?
I have a concern with section
working with a multiple page document on the computer. So I want to make sure I'm looking at the right section.
Yep. So if you go to page 51, part 13, relative to telemed provided by out-of-state psychologists.
Okay.
It's very specific to, and I believe this was an LSR that Senator Reagan put in, and I believe, because it's been stated that Dr. Warner requested this, who is a psychologist on the Board of Psychology, so I'm sure she can elaborate. But as Attorney Broderick indicated, the OPLC has also testified on this, but our concern is really making any changes to the telehealth law. We're very concerned about that because it's a brand new law, and there's a telehealth commission that we believe they're just starting their work, and they are going to be reviewing all sorts of different opportunities to potentially change the telehealth law. And we believe that's a good vehicle or a venue, if you will, to present any suggestions from different clinicians relative to modifying their how telehealth impacts their license.
Okay.
I hope I answered your question.
You did. Thank you.
Thank you.
Great job, Paula.
Okay, are there any further questions for Ms. Minahan this morning? Seeing none, thank you very much for your testimony. The chair is going to call Mike Sillen.
Mike, you should be able to unmute yourself.
Yes, thank you, Aaron. Great job quarterbacking that. No mess ups yet. I also want to thank Madam Chair and sincerely, I hope that your daughter is fine. I want to thank the rest of the committee. And I also want to thank Senator Bob Gaida and Pericles Karatis for helping me through this process. My name is Michael Sillen. I live in Freedom, New Hampshire. I'm a co-founder of the Aroma Joe's franchise brand. We currently have 73 stores open and operating on the East Coast, including 36 stores in New Hampshire, of which I am the owner and operator of 19 of those locally owned, of those locally operated stores. Our first store opened in 2000 in East Rochester. We operate our business out of Dover, New Hampshire, and I am fully supporting Senate Bill 133 FN Section 14, the sanitary production and distribution of food. In August of 2019, as Colleen and Michelle have already testified, they updated the food protection rule. They adopted the 2017 FDA food code standards for the sanitary production and distribution of food. We believe this was done by reference without full public hearing, feedback, or notice from stakeholders. The rule change required that every food service establishment have a certified ServSafe employee on site at all times. Our stores are a drive-through coffee kiosk that generally only have one barista working at a time, which means that this rule change will require us to train every single one of our baristas to become a certified food protection manager. Firstly, this would be a major financial cost to our business. We currently, and this is just the stores that I own and operate in New Hampshire, not all 36. And I have provided written testimony that the committee could review, and I'm available to ask any, I'm available to answer any questions that you guys may have after you receive my written testimony. But out of the 275 current New Hampshire employees, 15 of our management team are CFPM certified through ServSafe. I want to quickly explain the financial burden because I think it's important, because on the surface it may not seem that there's much of that it's not that big of a deal to become certified food protection manager, but there is a huge financial burden to a company like ourselves. So if you eliminate the 15 people that are currently already certified, that would leave 260 employees at a cost of $165 per employee. That's just shy of $43,000. And in our experience, only 40% pass this course the first time. And the reason for that is we are not a business that serves food from its raw state to the public. We are simply reheating pre-cooked products or thawing and serving baked goods. There's no necessity or no real logical reason to train our employees on the safe handling of raw chicken or shellfish, and that's the problem. The certified food protection manager course dips into all that, and that's why we believe that in our experience only 40% pass that course the first time, which it results in 156 employees needing to retake the test at a cost of $55 per employee for just shy of $9,000. Furthermore, if any of those employees fail the course 3 times, they're not eligible to retake the course for 1 full year. In addition to the cost of the course, we are also obligated to pay for the hours spent taking that course. And the average would be 260 employees at 6 hours times $8.50 an hour, which is our average employee hourly rate. That's just over $13,000. And then to retake the cost is 156 of those people that do not pass. And at times a couple hours, because it's only 2 hours to take the exam, again at $8.50, is just shy of $3,000. The total cost to currently certify our staff to become CFPMs is conservatively around $70,000. This is a fight that we took up with Bob Guida prior to COVID. And I know that there's been some mention of the pandemic today, and I want to keep it as separate as I can because it is unrelated, but unfortunately it does tie into the restaurants in our state. In order to be able to afford this rule, it's too troublesome right now. It's too much of a burden. And I believe that the intent of the rule, like Colleen and Michelle have testified earlier today, we currently meet or exceed the intentions of this rule. We, as a 73 store company up and down the East Coast, we currently have an internal management and inspection program that we currently take into we have great pride in that. We currently go out and monitor every month all of our stores, and it's not I think it's just been missed that a business like ourselves have been dragged into a rule change that there was no outlet for me to explain how detrimental this was to our business. The majority of our employees fall into one of three categories. It's either their first job, they're under 18 years old, or they're just seeking part-time or a seasonal job. We're very proud of this. For a lot of our people, it is their first job, and we like to schedule their hours around all of their social, educational, and athletic commitments. And as a company, we try very hard to promote from within and try to retain these employees, some of which of our management staff have been working for us for over 14 years. But in addition to this financial impact, operationally, this rule shouldn't even apply to our business for what I just said. We do not serve raw product cooked and then served to the public. We are simply reheating product that is already cooked. We have several policies that protect and educate everyone, from our delivery drivers, our consumers, our employees, all of which well exceed the original intention of the rule, and that we have provided we've provided all of this documentation to DHHS, and we did receive a variance that Colleen had mentioned earlier today in her testimony. We believe that small businesses like ours that do not handle raw food should actually be exempted from those rules, and that's why we fully support Senate Bill 133, Part 14, and we believe we have met or exceed all of the safety standards. So again, I want to thank everyone for their time today and allowing me to speak. And if there are any questions, I'd be more than happy to answer them.
Thank you very much for your testimony, Mr. Sillen. Are there any questions from the committee? Okay. Mr. Sillen, you had mentioned that you believed that there hadn't been any kind of a public hearing on the proposed rule change. When did you find out about the rule change?
We found out because we have multiple stores in New Hampshire that are not only subject to state inspections, some of our towns that we operate in, which include Rochester, Portsmouth, and Dover, Bob Vino, who is the health inspector in Rochester, came out, I believe, in January and called us out on not having a ServSafe certified or a certified food protection manager on site at all times. This was brand new news to us. I was shocked. At that point, I reached out to Pericles Caradas through Legislative Solutions, and I asked for some help. And prior to that, I had not heard about any public hearing, any feedback, any notice of any rule change. And maybe there is an issue there. Maybe there is a bridge of communication that needs to be addressed to the public business community to understand what's happening at the New Hampshire state level, so that we have a voice, because I was not aware of that. And at that point, the rule had already been applied, and we were under it. Since then, not only have we applied for a variance at the state level, Bob Vino in Rochester gracefully allowed us to submit a waiver, and we have since applied for and received one for our stores that operate in New Hampshire, in Rochester, New Hampshire.
Okay, another question. You had mentioned that you have stores in other states. Have you encountered this in those other states?
No, absolutely not. We have stores in Maine, New Hampshire, Massachusetts, Pennsylvania, and Florida, and only New Hampshire has adopted that federal 2017 sanitary production and distribution of food. The other states have not done that. We do have, and always have had since we opened, required as a brand for all of our 73 stores that every single store have at least one certified food protection manager on the schedule for a minimum of 8 hours per week, but are also available to anyone that's working in the store and any inspector that would happen to come into the store, that they are available every hour of every day that we are open, which on the average amount that we are open is 5 a.m. in the morning till 9 p.m. at night, 7 days a week. And that's the financial challenge, because a lot of our baristas are working alone, and a lot of them, will cover a shift state to state or town to town. So I would literally have to certify every single employee to give them that manager certification, and that's why the financial burden is huge.
Okay. Thank you for answering my questions. Are there any further questions from the committee? Okay, seeing none. Thank you very much for your testimony this morning, Mr. Sillen. Aaron, I've gone through the list of folks who had signed up to testify. I'm willing to bet there are people in the waiting room.
I do see two people. It looks like former Senator Bob Clegg.
Okay, why don't we go ahead and put him through?
Thank you, Madam Chair. I did sign up, but there was a little bit of an issue this morning, the same time you were having an issue to start. So I thought I got something back from Josh. He thought I had signed up, but I'm here to talk about Section 14 and the DHHS rules. Now, I want to point out that when Senator Guida spoke today, he spoke about the rule and the fact that there were things in the rule that don't belong there, including the fact that they believe that they can usurp the statewide building code and ask for you to submit septic plans to them, plumbing plans, all of the things which are local control or state controlled. So it's a duplication, and you don't really know it until after the fact. I'm well aware of the problems in this section because the Bath Brick Store, the oldest continuing general store in the country, had asked for my assistance when they were redoing their septic system and their kitchen and the entire store. And every time they turned around, they would be hit with a new regulation. And similar to Aroma Joe's, they were hit with the idea that they now had to certify everyone, and they have a serious turnover in help in the store because it's typically high school kids. But now the idea that we shouldn't codify a rule, as most of you know, I spent 14 years as your colleague, and there's not supposed to be a rule unless there's a law. But we systematically go above and beyond as a department, and we make laws because they're easier to slide them through on the rule process. Now, when they do that and they get caught, GelCar has a choice of either letting it go, or GelCar has to do the same thing that Bob Guide is doing, take what's necessary out of the rule, codify it, create a law, and then look to the DHHS and say, okay, here's the law. Now make a rule on how you're going to enforce it, but not tell me that you can't make a law because I've already got it in rule and it just makes it tougher. There's a lot in this section that's been changed. A lot of it has been reviewed by the Restaurant Lodging Association and other people across the state, and they say it would make it much easier. None of it takes away from the safety aspect. In fact, some of it's actually better because now we know who's doing the septic systems, we know who's doing the plumbing, and I personally believe that the local community should have the final say on how many people you can put in that establishment, not the state, and how many sinks you need, how many restrooms you need. There's codes out there, and the Building Code Review Board goes over constantly. I believe they still meet once a month, and there are changes, as you know, Senator, because you've sponsored some this year. Mm-hmm. But the rules need to be fixed, and the only way you can fix that rule is to do what Bob Guida has done and create a law that says, here's the law, and not the other way around. And I agree that we had a Zoom meeting yesterday and John Williams said, can we work together? And we did. We added back in some of the 2017 issues that they felt were absolutely necessary. But the idea that we wait until they can go to the Rules Committee and fix it on their own doesn't make sense. One, every place else that I've been listening to, supposedly it's going to take at least 9 months before anything can be done to be handed to the Rules Committee because they're inundated because of COVID. We can't wait 9 months. As you heard from Aroma Joe's, they don't have that kind of time, and neither do the other small businesses. Some people have just said, I'm done with the state, I'm walking away. And you know, every year we hear people run for office and say, I'm going to lessen the regulations, I'm going to create smaller government. This is a perfect example of where it's gone just the opposite. And so I ask you to move forward with this bill. Senator Guider has said he's bringing in the amendment. The amendment, as I said, lessens some of the things that they'd done. Instead of reversing everything to the 2015 code, they're taking the 2017 with the changes that we made inside. Now, if anybody would like a mocked up, color-coded view of what we've done, I'd be more than happy to supply it. I tried to supply it earlier, but again, I couldn't get through to the system so I could actually email it to you. I'll take any questions. I'm familiar, as I said, with this entire process, having had to suffer through it with the brick store in Bath. And I'll admit, I'm the one that made the changes inside because as a person who's been in the trades for, well, since I was 15, and someone who's had to deal with this, and someone who's been on your side, I don't see any other way of doing it so that it's fair to the businesses out there. And thank you.
Thank you very much for your testimony this morning. Are there any questions? I think Senator Prentice has a question for you.
Thank you, Senator Carson and former Senator Clegg. I love the brick store in Bath. I used to live up in Woodsville, so it's great to have that come up in the conversation today. I was just curious. I wanted to hear if the Department of Health, are they still on the call? Do they have any? I'm just curious to hear what they have to say about Senator Clegg's statement or testimony. See, again, I want everybody. It sounds like folks are working together. I just want to hear a little bit about that from the department side as well. That's all.
Okay. What we can do, Senator Reagan has his hand up. He would like to ask Senator Clegg a question. So why don't we have that happen, and then we can see from Aaron if there's someone from the department who's still on the line that would like to answer your question.
Thank you.
Senator Reagan?
Madam Chair, my comment is that as the chairman of JOCAR, I would like to defend the committee and say that we do not and are always on guard against people trying to create legislation through rules. So that doesn't happen. And I know it's out there as a belief, but we don't allow that.
Okay. Thank you very much, Senator Reagan, for your questions. Aaron, can we see if there's someone that's still from, and I'm trying to look back through my notes, who actually testified?
I do see Colleen Smith.
Okay. Let's bring Ms. Smith in, and that way Senator Prentice can ask her question.
Colleen, you should be able to unmute yourself.
Good morning. Again, for the record, my name is Colleen Smith. I'm the administrator of the Food Protection Section within the Department of Health and Human Services. Thank you, Madam Chair and members of the committee, for inviting me back. I'd be happy to answer any questions you have.
Senator Prentice?
Absolutely, Colleen. I just, again, I asked this before, so I'm just going back to it. What is working together with Senator Guida and your department and these concerns that have been brought forward? What does that look like? What's the immediate future on this so we can hopefully get this resolved?
So I will try to answer this in two parts. So we have been working over the last several months to address the concerns, as Mr. Sillen from Roma Joe's had mentioned regarding the certified food protection manager requirements, so that in a situation like his business model and others that make low risk food, if they have at least one on staff, which in his testimony he did indicate that they do, that they would be absolved from the requirement from having someone during all hours of operation. And that would also apply to like an ice cream scoop shop, similar types model of business with low risk menu items. So we have addressed that in some draft rule making. We plan to work on this with a target of a gel card date of May of 2021. So we feel like that's the most expeditious way of resolving the issue concerning the certified food protection manager requirement. Just to provide some clarifications on the references to septic documentation or plumbing or building codes. So currently our rules refer to the Department of Environmental Services rules and requirements for septic systems. So we simply ask for that documentation to show that they're in compliance when they are opening a food establishment. And we ask for that for a brand new establishment as well at change of ownership, because sometimes what happens is businesses over time have changed what their food service model is from when they were originally licensed, which could have been 10, 20 years ago. So before a new establishment or a change of ownership, we ask for that documentation to show that they are in compliance with the Department of Environmental Services. So, the last thing we want is a septic breach. We want to make sure they have that capacity to run that food service operations safely. So we don't approve those systems. We just ask for documentation that they're in compliance with the Department of Environmental Services. And the plan review process, which we have, is it's not building code compliance. We refer definitely to the local officials for ultimate jurisdiction on building code compliance. We just do what we call a plan review process. So a new business is required to submit their plan for their kitchen layout. And so this helps us assess, do they have the proper amount of refrigeration for what they're intending to do? Does this show hand sink layouts? Do they have a 3-bay sink? So we're looking particularly, do they have the elements in that kitchen to run the food service operation safely? We're not looking for egress, exits. That's all building code. We're just simply providing a service to that business so that they can have our expertise in, yes, we feel like you have enough refrigeration. We feel like you have the proper amount of hand sinks to ultimately be able to run that operation safely. So by no means is it, we're not invoking any other oversight for building code enforcement. It's just a secondary, helpfulness to the food industry that we review their kitchen layout. And we do copy the local plumbing officials and the building code health officer on any plan reviews that we do, because sometimes they're not even aware that those things are happening in their town. So we definitely let them know that we are aware of a new construction or renovation happening. So hopefully that provides some clarity, but happy to take any follow-up questions.
I believe Senator Prentice has a follow-up question.
Thank you, Senator Carson. So provides clarity and then some. Between now and May, what happens? Do they have to still have the food protection worker on site? I thought I heard that there was a waiver in place. I had to toggle out to a Health and Human Services meeting, so I'm back. I just want to make sure that I didn't miss this.
So Kurt, we have an agreement through the variance process with the Roma Joe's. We approved their variance. So currently they do not have to have that certified food protection manager at all times. They just have to have one available during the hours that they are open.
Okay. Thank you. Thank you, Senator Carson. Thank you, Carson.
Thank you. Thank you very much for your additional testimony, Ms. Smith. Aaron, you said there was one other person in the waiting room?
I see there are at least 5 people with their hands raised. However, 3 of them haven't spoken yet. Do you want me to go with them?
Yes, we're going with the folks that have not spoken yet.
The first person is under the name PFFNH. If you could please identify yourself.
Hi, can you hear me?
Yes, we can.
Hi. Thank you, Madam Chair and members of the committee. My name is Brian Rill. I am the president of the Professional Firefighters of New Hampshire. And I am speaking today in support of Senate Bill 133, Section 3 and Section 11. I apologize for not previously signing up to speak. I had not intended to speak today and believe that my written testimony that I provided was going to be sufficient. But after hearing some of the testimony earlier, I just wanted to clear up what I believe may be some confusion in regards to Section 3 on the Interstate Compact and what exactly that means for New Hampshire as a whole and the cities and towns. And part of this is, while I appreciate the discussion about allowing members in from out of state during an emergency crisis with a pandemic included, it was mentioned that this actually hasn't been being utilized. And I do want to highlight the fact that the governor already has the rights in this case to allow out-of-state resources to come in during a state of emergency. So what we're talking about here, again, is not an overwhelming emergency crisis. We're talking about routine day-to-day emergency response. And by allowing the self-deployment of resources from out of state to come into New Hampshire, it not only creates confusion and chaos within our already existing EMS system, but it creates a possible risk for patients. And what I mean by that is we all operate under a standard of care through protocols that are developed through the Medical Control Board. And those are New Hampshire physicians that take into consideration the New Hampshire demographic, the limitations of New Hampshire hospitals, as well as best practices and policies and guidelines. And we function under these protocols with the assumption that our physicians in New Hampshire know what's best for the patients in New Hampshire. And by allowing routine day-to-day emergency response from out of state and personnel to work under their home state's license, it creates confusion within the system. Now you have multiple providers working under multiple scope of practice, and it just dilutes what we've done here in New Hampshire. Furthermore, we have department heads in every city and town that is tasked with the responsibility to develop their own emergency response guidelines, and that includes mutual aid agreements that are already in effect. And they develop their mutual aid agreements due to what's best for that local city and town. And I think where we find ourselves getting into a little bit of trouble here is when we try and decide what we should implement for response at the state level, when it's the department heads in these individual communities that know what's best for that community. So I just want to state for the record again, I'm in support of Senate Bill 133 and Part 3 for these reasons, and I'm happy to answer any questions I may be able to. Thank you for your time.
Thank you very much for your testimony this morning. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
I do see the next person is Dr. Debbie Warner.
Okay, let's put her through.
Dr. Warner, you should be able to unmute yourself.
Yes, indeed. Thank you very much. This is Dr. Deborah Warner. I appreciate the opportunity to testify before your committee, Madam Chairman, and the senators of the Executive Departments and Administration Committee. I am the speaking on behalf of the Board of Psychologists. We have asked Senator Reagan to bring forward the Section 13, Roman 13 of your bill, which was LSR 0277. And this has a very fast track for a telemedicine license for psychologists. We do already have the SIPACT, which is an interstate compact, which is very good, but it is not widely subscribed to yet by many states. There are only 14 states, and the nearest one to us is Delaware. And the board would like to make sure that we can, our citizens of New Hampshire can access care from neighboring states to whom they might visit, or as well as they may do this remotely on their devices. We currently have emergency licenses in telemedicine that are issued for free and go very, very quickly by the administration at OPLC. And I heard Attorney Broderick's testimony, and he and I have spoken about this. And we just wanted to make sure that you are aware that the type of license this is very, very fast to issue. It would be done administratively and not through an extra examination and review by the board. And being that the administrator could issue this type of license in one day, and in fact, as OPLC is putting applications online, this could actually be automated, and people from other states, psychologists from other states who need to access patients in New Hampshire and help them could do that really very, very quickly. And this is a good thing to do. We have neighboring states, Vermont, Maine, Massachusetts. Those states have providers that are needed by our citizens. This actually will not benefit the psychologists themselves in New Hampshire. It will benefit the citizens to have a greater pool for immediate use, especially after the emergency is over. And we do still need to have some kind of very specific license for telemedicine. The telepass is not required for New Hampshire psychologists. They already have a full license and can go ahead and do telemedicine in New Hampshire. This is sort of a a la carte item in contrast to the compact license, which people can get if you were a member of a state that is a member of the compact. And as I said, there are only 14 of them. That process takes about 2 months to get that license. And it also costs $440. We are imagining with the small administrative handling that this would be $100 or less. And we don't know what the fee is that OPLC will assign, but they would base that on the amount of administrative work to handle it. These would not be automatically renewable. A person would have to renew it themselves, and there would be no entitlement to renewal or being noticed of that. So that is how we did this. Our board is very much in favor of this because we would like to make sure that following COVID, that we can still maintain a very high degree of access to psychological care for the citizens of New Hampshire. The Mrs. Monahan had brought up a point that it could be a slippery slope for other license boards. We have 54 license boards in OPLC, I am told, and they all have different sorts of criteria for their standards of care. And in New Hampshire, psychologists are not required to have an in-person visit before delivering telemedicine. And the board does diligently bring forward their standards and rules and make sure that we have very good standards of care. It does not change the telemedicine chapter of law. It simply goes into our own statute, chapter 329B. I'll take some questions.
Okay, thank you for your testimony this afternoon. Almost, yes, it's the afternoon. It's good to see you again, Dr. Warner. Are there any questions for Dr. Warner? Okay, seeing none, Thank you very much.
Senator Carson, I do see 3 people with their hands up that have not spoken.
Okay.
The first person is Chris Stawaz. I'm sorry if I mispronounced your last name.
Okay, that's fine. We'll see. We'll hear from them. Mr. Stawaz?
Yes, can you hear me?
Yes, we can.
All right, thank you for the opportunity to speak to you this afternoon about Senate Bill 133. I'm here today to speak in opposition of Section 3, the proposed repeal of the New Hampshire EMS Personal Licensure Interstate Compact, known as Replica. My name is Chris Stawaz. I'm a lifelong New Hampshire resident and reside in the town of Hollis, New Hampshire with my wife and family. I've been a nationally registered paramedic for the last 35 years and have spent my entire adult career in the New Hampshire emergency medical services industry. I'm employed by American Medical Response, which is New Hampshire's largest medical transportation provider, and I am currently the regional director for AMR in New Hampshire and Maine, as well as the Northeast Regional Director of Government Affairs. Replica solved a potential problem for New Hampshire. It created a specific and defined process for licensed qualified EMS staff to safely cross state borders when needed in the performance of their duties without having to hold multiple state EMS licenses. New Hampshire participates in approximately 43 interstate compacts. Replica is similar in language and intent to all of the other licensure compacts that New Hampshire has chosen to participate in. Now more than ever, we need this compact to assure that our New Hampshire communities will have the EMS personnel resources that we need when we need them in times of unplanned national emergencies, such as the ongoing worldwide pandemic. When New Hampshire became the 15th state to join Replica in 2018, it was the result of a collaborative effort of numerous New Hampshire EMS stakeholder agencies, including the fire service, commercial ambulance providers, New Hampshire hospitals, and the many of the volunteer EMS community members we're so lucky to have in our state. The compact is now fully operational, and there are currently 21 member states with more actively working to join. The Replica compact does not provide a multi-state license. It does not create automatic reciprocity. It does not pertain to ambulances, only licensed providers. It does not have the authority over EMS or ambulance service licensure in New Hampshire. It does not supersede the state of New Hampshire EMS laws and rules. It does not allow for self-deployment, and it is not for routine day-to-day operations or response. Replica does extend a privilege to practice in member states under authorized circumstances to qualified, vetted, licensed providers for specific purposes only. It stands up a national coordinated personnel database which allows the New Hampshire Bureau of EMS to view complete license histories of individuals, share real-time significant investigatory information, share license discipline history, and receive cross-border notifications of out-of-state adverse actions. It expedites filling a need in large-scale unplanned incidents that have drained local resources and require additional personnel, like a pandemic. Notably, it also creates an expedited licensing process for members of the military and their spouses separating from active duty. As a recognized patriotic employer of the Guard and Reserve, this is a critical component that we feel brings great value to our 200+ employees in the state of New Hampshire. In closing, if there are improvements or corrections needed or desired to this compact, then I would ask that this committee find a way to make them together through amendments to the current system, rather than exiting the entire agreement and starting from scratch again. Thank you very much for the opportunity to speak today about this, and I am happy to answer any questions the committee.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none. Again, thank you very much. Who's next, Aaron?
The next person is David Pelletier.
Okay.
David, you can unmute yourself.
Good afternoon, Madam Chair and members of the committee.
Good afternoon, Mr. Pelletier. Thank you for waiting. We appreciate that. Which section of the bill are you going to be speaking to?
I want to speak to Section 2 of the bill, and specifically, I support the move to OL, Office of Licensed Professionals, or whatever, Office of Professional Certification. but I'm opposed to the limited plumbing specialist. So just a little history. I was on the board for roughly 8 years. I've been off the board now for about 10 months. And this issue of apprentices not being able to do work has come before the board many times. By the board rules, an apprentice has to work under direct supervision. While I was still on the board, we had talked about a change in the rules after 1 year, just changing it to supervision, which could be by electronic means. It'd be a sort of a daily check-in with your journeyman or master plumber. That got a lot of feedback from the industry. They were opposed to it. So we changed the rule or the proposed rule, and I called over there today, and that rule is still at the Mechanical Licensing Board in their legal division. But we had made a change that it'd be 2 years of direct supervision, and the final 2 years of your plumbing apprenticeship were supervision, which could be by electronic means. It was a daily check-in, where a plumbing apprentice could go out after, in their 3rd or 4th year and work pretty much independently without the journeyman or master nearby, and work in a home or work on any job, actually. So I'm just wondering why we need to, by law, change or make a new license as a limited plumbing specialist, which looks like it would be someone lower or a different standard, a lower standard than a plumbing apprentice. We also, while I was on the board, changed or made a provision where someone coming into a plumbing apprenticeship at year 1 could take a test and test out of the entire first year. So they would effectively come in as a 2nd-year apprentice, which would mean they'd work 1 year under direct supervision of either a master or a journeyman. And then if this rule change happens in their 3rd and 4th year, they'd be able to work fairly independently with electronic supervision or a daily check-in. So I'm just opposed to it on the grounds that I believe the board already has the authority or the rule in process. It hasn't gone to JELCAR yet, but it's already in process where they can do this. And I don't see where this law benefits an individual in the plumbing industry at all. Lastly, I would say that in the gas industry, they have progressive licenses, but they also have off on the side, a license hearth installer. One of my last meetings on the board, a hearth installer came in and wanted to become a licensed gas fitter. Now, for him to do that, there was no way for him to become a licensed gas fitter other than to give up his hearth installer license and become a trainee, and then progress through the trainee program to become a licensed gas fitter, an appliance installer, and then a service mechanic. And I just see this as another stumbling block to someone getting into the trade, where they become a limited plumbing specialist. And then they have to give that up to become an apprentice, to become a journeyman, and then a master, and own their own business. And that's all I have. Thank you.
Hey, thank you very much for your testimony, Mr. Pelletier. Are there any questions from the committee? I see Senator Kavanaugh has his hand raised.
Thank you, Madam Chair, and thank you, Mr. Pelletier, for taking my question. I was just kind of surprised to hear that too. I think in the electrical industry as well as plumbing, an apprentice will be working under the master's license. And I guess my question is, and I guess I have to look at it. So if this specialist was enacted working on their own, what kind of insurance would they have to cover? They would have to cover insurance, as I assume right now it would be covered under the master license. Is that correct, or am I off base with that?
I honestly don't know what they're proposing for this specialist, But I would assume that the specialist would still have to work under a master, because a master is the only one who can own a company, have a mechanical business entity, and needs to be insured and all that. So I don't know what the benefit of it is, because you certainly don't want a limited plumbing specialist opening up their own company and working out there by themselves.
Okay, thank you.
Yeah.
Are there any further questions? Seeing none, thank you very much for your testimony this afternoon. Okay, who is the next person, Aaron?
There are 4 people with their hands raised. They have all spoken, but one of them is Senator Gaida.
Okay, let's put Senator Gaida through.
Thank you, Madam Chair, members of the committee. The very problem we're trying to solve was manifested in the last speaker. This is a request from numbers of small businesses in the realm, supported by the mechanical board, because it understands the problem in the marketplace. We are losing good people because they don't want to wait 4 years to have to be supervised for changing the washer in a sink. This bill is common sense. It's requested by the industry. It is approved and supported by the mechanical board and the fire marshal and the OPLC. What it does is it provides an opportunity for young people to accomplish a level of proficiency and work on their own under a master still, because they don't have a license. Okay, that's pretty obvious. But it gives them the ability, and it gives the master plumber the ability to have more than one employee capable of doing these things and thereby grow his or her business. Okay, this is a good bill. And again, when you have people throwing up all kinds of roadblocks, that served, with all due respect, on a board that has agreed that this is a good bill, I think that I would rather go with the board that's in existence today, because they understand the problem and the world has changed. Thank you very much.
Thank you very much, Senator Gaida. Are there any questions for Senator Gaida? Right, seeing none, thank you. Who else, Aaron?
The next person I see is Mike Sillen, who would like to speak again.
Okay, at this point, I don't want to do a lot of back and forth between people. So let's put Mr. Sillen through and I'll speak with him. Mr. Sillen?
Thank you, Madam Chair. I just wanted to comment quickly on the variance waiver process that's in place right now. That is helpful, but I'm looking for a more permanent solution. So when Senator Prentice asked about DHHS's involvement with working with Senator Gaida and the constituents on where are we at, I just wanted to add the piece that I truly believe that there is a more permanent solution. This committee today is great, and I thank them for their time. Senator Gaida and also Colleen and Michelle and even myself, we may not be here next year, 2 years, 3 years from now. And I worry about the variance process can change with the individuals that are in charge of that. So that's why I'm in support of this bill today, is because I want a more permanent solution than the variance process that exists.
Okay, thank you very much, Mr. Sillen. Are there any questions from the committee? Okay, seeing none, thank you.
The next person I had was former Senator Clegg.
Okay, let's put him through.
Madam Chair, I just wanted to point out that the variances are temporary. Not everybody knew they could get a variance, so we have a whole lot of people out there that are still under the impression that they have to do this. We also realize that there's doesn't seem to be any place for classes yet. And again, that's due to the pandemic. So a lot of people don't know what to do. And as far as what the department said about the code issues, if that's how they believe things should be, then we're going to be in agreement, because that's exactly how it's laid out in Senator Geider's thing. So I think we've corrected a few things, but I just wanted to point out that there are a lot of people out there don't have variances. Thank you.
Thank you. Are there any questions for Senator Clegg? Okay, seeing none. And so let's get to the final person, Aaron.
The last person is Justin Romanello.
Okay, let's put through Mr. Romanello again.
Thank you, Senator. I appreciate the time again. Just a point of clarification, when the Section 3, when replica was first introduced, there was additional language in 153A20 that prevented replica from being used for day-to-day operations, and that replica truly is for emergency purposes based on the fact that it can't be used for day-to-day operations. And is certainly another tool other than the governor having to use EMAC for the request of resources. So that is in effect, and I'll be honest with you, it does limit the benefits of replica for our border communities if in fact a border state was part of the compact. So with this safeguard in place to prevent the day-to-day operations, I believe it was introduced to at the request of other entities at the time of its adoption, and I think that it will continue to safeguard any of those arguments moving forward if this was actually removed from 133. Thank you for your time, and certainly can answer any questions.
Thank you very much, Mr. Romanello. Are there any questions for Mr. Romanello from the committee? Okay, seeing none. Thank you very much. Aaron, is that it?
That is it, Senator.
Okay, I'm going to go ahead and close Senate Bill 133. Can I get a motion to adjourn for today? Okay, moved by Senator Prentice. Is there a second? Seconded by Senator Kavanaugh. I'm going to go ahead and call the roll. Senator Prentice?
Prentice, yes.
Senator Kavanaugh?
Yes, and good luck with your daughter today, Senator Carson.
Thank you. Senator Ricciardi? It's been a long morning.
It has. I had to stand up. I couldn't sit any longer, but yes.
Okay, thank you. Senator Reagan?
Yes, and my apologies for my recorded outburst previously.
Okay, thank you very much. And Senator Carson, yes. We are finished for the day. I'd like to thank Mr. Lapine and Mr. Jones for helping us through a long bill with a lot of testimony. And so please, gentlemen, have a great afternoon, and thank you. And thank you to the public for tuning in and giving us your thoughts. Thank you very much. Take care, everyone. Bye-bye.
Thank you, Cam. Take care, Senator Carson. Bye, everyone.